हाँ हाँ हाँ।
हेलो
हेलो।
हेलो मैम, आपको आवाज़ आ रही है?
हाँ जी हाँ जी, आ रही है, आ रही है।
कैमरा खोलेंगे मैम आप अपना एक बार?
आइटम 22 है।
कैमरा कैमरा ऑन करेंगे मैम?
कैमरा ओके।
थैंक यू।
थैंक यू।
Thank you.
आइटम 801।
Yes, thank you.
ओके सर, थैंक यू।
For mentioning 801.
May it please, Your Lordships. Lordships, this is a matter where Your Lordships had issued notice. In the meantime, the accused daughter is getting married on 29th November. So if Your Lordship may kindly have it any date after Diwali before 29th of November. I've already served the standing counsel.
Diwali would be difficult.
Before Diwali, Your Lordship, he's been in jail for more than 3.5 years. Maximum sentence is 5 years. More than half the time is already spent. Your Lordship may please.
Okay, we'll put it in the next week, maybe.
Extremely grateful, ma'am. Extremely grateful.
802.
Lordships, I'm mentioning a bail application. The tentative date is being shown as 24th of November.
Not to delete.
Grateful.
803.
Please, Lordship. Lordship, I am mentioning for non-deletion of this matter. Non-deletion, Lordship. My Lord, in the same matter.
This is that Provident Fund matter.
No, Lordship, this is recruitment to the district judge.
Okay.
My Lord, in the same matter, I may be permitted to file
This is
rejoinder.
the Jharkhand,
Yes, my Lord. Yes.
where the process was abandoned or something like that.
Absolutely, Lordship.
Okay.
I may be permitted to file rejoinder in the same matter.
You file rejoinder before the next date.
Very good. I'll
804.
Good morning, my lords, my lady. This is a custody matter that I'm mentioning, your lordships. It's showing up as likely date November 20th. My prayer would be not for that not to
Not
be
to
deleted.
delete.
It's a fresh matter, my lady. And there's some allegation that the mother took the child from the US and has returned to India, contrary to an American court's order, with custody vested with the father. So that's the tricky bit to it.
We'll have to lay down
Yes.
the law on this.
Yes, we do.
Because matter after matter is coming.
So just only that it not be deleted on the 20th.
Not to be deleted.
So grateful. So grateful.
Item 805, my lord, it is a 2019 SLP. Noted for issued on the stay as well. Suddenly, my lord, what has happened? The case is concerned with the partition decree. The execution court has drawn the final decree and directed for taking immediate possession, my lord. So I filed an IA for directions, my lords. It may be listed, my lord, in November or
Indirectly, you are asking for stay.
yes, my lord.
Okay, whenever it's listed, you
They actually, my lords, they
after the Diwali.
yes after Diwali, my lord. December also it is fine. Yes, sir.
06.
Yes, Maliki, this is the bail matter of ex-director of Amrapali Group. Earlier, there was no constitution of the bench. Now, I was informed by the registry the bench has been constituted. So, no effective hearing did not take place because of the
Not aware about it. Let's see.
I had mentioned before the Honorable Chief Justice. He said that he'll form a bench. The registry has confirmed that the bench has been
I'm still
constituted.
not informed, so I can't say.
So, my lady can list the matter.
I can't without being informed. I'm not aware about it.
Court master can inquire if the bench has been constituted.
Let it be, you may mention maybe on Monday or something by that time.
Which may give me liberty to mention it again.
Bench has to be formed.
About the bench, constitution of bench.
My lady may instruct the court master.
No, you may mention it again, maybe after I'm informed.
My lady,
The next week or something.
because I had mentioned it before the honorable.
Next week,
No,
I'm not aware about.
I
I'm
had
not
mentioned it before the honorable chief justice before the vacations. So he informed that the bench has been constituted.
Then when it is, I don't know whether, how it is informed.
My request will be, prayer would be to request the court master to.
Say anything now.
My lady, then I'll again mention it on Monday.
May I just mention?
Unlisted.
I'm sorry, Lord.
Is your house being demolished?
No. I'll come on Monday.
Is the execution order
No.
Even sir,
Hanging.
fall down.
then
I'll come on Monday.
circulated notice.
Oblige me.
1.
Please, Your Lordship, I appear for the wife.
Malad, I
Petitioner
accept the
in one
husband.
and respondent on the.
Malad, there's an order of 16th of August in which the matters have been disposed of.
Possibly some correction. in-
Yes, Malad. So,
Let the correction be effected as contained in the office report of 11th October 2023.
I'm grateful.
Item 2,
Letter has been circulated for rejoinder.
Letter,
Please.
adjourn as per.
Date
letter.
3,
The letter has been circulated.
Adjourn as per letter.
item 4,
Yes. On the last occasion, this court had been pleased to ask them to file a response, and when they file a response, they admit that people have got bail. They've already stated that. If this court is kind enough to have the reply.
Who is for the directorate?
I see a passover for the ASG. He's not here. He's on his.
Passover, all this PMLA matter you are asking for. Passover, people are in. Wait. When you are addressing us kindly, concentrate on the court rather than the mobile. Monday,
ma'am?
list on Monday. As accommodation is asked for on behalf of the Directorate of Enforcement.
What's your good name?
Manisha.
Hmm?
Manisha Dubey.
Since how long you are in the Supreme Court?
3 months.
Huh?
3 months.
You must know what should be done, what should not be done in the court.
Immediately.
This is not the way. When you are addressing the court, you can't just play with the whatever message.
Again, you are doing that.
Sir, I was seeking
But I will
instructions.
speak to my young friend, I'll counsel her outside.
Sir,
It's our fault as seniors, if we don't counsel them, it's not their.
apologies, Your
It's
Lordship.
my
I
lapse.
was seeking instructions, so I was.
No, you can't say it's written like this. This is Supreme Court, highest court of the country.
Apologies.
There has to be some discipline, decorum.
Apologies, Your Lordship.
I will speak to my young friend and take.
The problem is collapse of the chamber system.
Yes, but it is, and not it's our lapse. As if we as seniors are not careful, this is going to reflect on advocacy, and it's going to be, we have to maintain the decorum.
So many things, we can't speak, but we feel very sorry about it.
I completely understand. I'll take it. Great.
item 5,
का स्पेस भी मैंने बना दिया ताकि आपको प्रॉब्लम.
Who is appearing for
Yes, I'll just indicate what.
the revenue? We
Yes.
hard this matter a bit.
CBI may not has been.
When did your clients?
Yeah, I'll just tell you my small request, because I have a very modest request. I want no coercive steps against the three parties
Who are they and when did
Yes,
they join the
yes.
post?
So I am first and foremost, I'm a statutory board, and I am respondent number 39 in the
There
main
can be any coercive steps which apprehend against the board.
No, so
Who are the two officers.
So Your Lordship correctly puts to me, who am I appearing for? So I'm answering that question. I'm appearing for the board, which is the respondent number 39 in the main SLP, and the applicant in the applications before Your Lordship. I'm also appearing for the president of the board. So that's very important.
When did he join?
Yes, he joined in 2022, August. So he has come in, I may have just made a little mistake in that date. Just give me a moment. I took charge on 23rd August 2022.
Okay.
All right, 24th August. The notification is, I think, dated 23rd. So I came in August 2022. So I'm very new, and I'll give you my background, etc., as far as the president is concerned. So it's a statutory board. The statutory board has statutory functions, which I'll be taking you through.
The last occasion, another officer was.
No, I'll come to that. So this president has come in August 2022, and the period with which these particular investigations, etc., are going on, Your Lordship should just know that, is what is known as it's for a test of 2014, but the events took place broadly between 2014 and 2017. Just keep that. That's the boundary. 2017. Then there was the removal of the earlier president, etc. Those are the main proceedings in this court. In the meanwhile, I have been brought in on the 22nd of August, and I'm going to, in August 2022, I have been holding charge, etc. I have nothing to do with whatever has happened in the past, but of course, I have to discharge my current responsibilities for the purpose of all primary education in the state of West Bengal. So this is one. So this is one officer. The other officer is arrayed over here as the secretary of the board, but I might just indicate to you, the person who's actually in harness just now is a deputy secretary, so that there may be some new appointments, etc. Yesterday there was some appointment, but that's also a person who is apprehended. Now, what has happened very unfortunately is that directions, as I had indicated on the last occasion, are being made to persistently, because now I have something even further. This court passes orders, And for whatever reason, the Calcutta High Court, probably unaware that there is a hierarchy under our constitutional system, is passing orders which are directly contrary to what has happened and what is being passed in this court in this larger set of cases. All right, that's a general observation. I'll endeavor to make that good. What my immediate concern is this, and let me indicate that. On the 18th of October, on legal advice, we were advised to make an application before this court. That is one of the applications which is here before the court. And the main prayer in those applications on the 18th of October was that you please stay further proceedings in a certain writ petition. It's not as if we've held a gun or anything. We've come through a proper or legal advice by filing a competent application over here. This application is mentioned before an appropriate bench of this court. It is directed to be listed in the first week of November 2020, 7th of November 2023. There's a specific date which is given. This fact of this application being made before this court is mentioned thereafter before the Calcutta High Court on the very same day, and by the writ petitioner over there in the Calcutta High Court. The High Court proceeds on a wrong understanding, or at least my understanding is it's wrong, and appears to say that, oh, you got no order, etc., or stay, etc., etc. You make this kind of application, and thereafter issues specific directions for coercive action to be taken against my clients. By my clients, I indicate your lordship is right. As far as the board is concerned, perhaps there's no apprehension of arrest so far. But as far as the president and the officer is concerned, they are summoned over there. And I'm going to take your lordships through those facts. He's made to the president, who has got nothing to do with the earlier scam. And it's most unfortunate as to what the kind of coercive questioning which is going on over there. Sorry?
Yes, you are talking about the other officer.
Yes. I am talking about the current president, my lord, the current.
President, yes, but there are two officers who are.
And there is one other officer, some deputy secretary. And he is also, on the last day when this matter came up, your Monday, when the matter came up and your lordship said, you please serve the copies and come on the other side. He was against the other officer was summoned and subjected to a...
When did he join the board?
But he joined on the same days after. He joined on.
I understand 2 days later. That means 2022. August 2022. These are professional officers, my lords. These are people who have got huge responsibilities apart from attending court litigation, which may be one very, very small part. But they are not being allowed to function. And I'm going to take you through these kind of orders which are being passed. And in the teeth of Supreme Court of India orders, this sort of a direction, and we come to this court. What do? We approach the court, we get it listed, and the High Court takes umbrage against that.
Where is the High Court taking umbrage?
Yes, now let's take it. So please take up first IA2. I'll require my sets of my papers are across 2 documents. So please first take up, please have before you, rather than take up, please have before you IA 222598. That's one request that I have.
She is there for the CBI. I can see her on the screen.
Yes,
Yes.
that's all
I
right.
believe she is there.
Yeah, that's fine.
So,
Where is she? Can you unmute her?
she was there half a second back.
Her name is.
Yes.
Just please, can you go out?
So she may have to respond to any. First out. I believe so.
Your lordship, we kindly indicate a date in this matter.
Yesterday, somebody said Mr. Raju is appearing, therefore.
That was to be.
Yesterday, I have no idea about it. Now, let us just take up my application.
Let us find out.
I saw at item 5, Aishwarya Bhatti.
You connect. Is there a telephone number?
There in Allahabad, so that they can get the post-office and staff up, like the final hearings are going on there.
Madam,
I think
you are. Madam, this court is there also.
Take up IA 213931. It will take me a little time to explain this context. Please take up first IA 213931 of 2023. Please, Your Lordships have it. There are 3 IAs there. I'll also request the court to keep available 222598.
Okay.
222598, and the third IA is 220234. But please, for the present, take up IA 213931.
And which is the order?
Yes, I'll just come to that in a moment. Your Lordships have 213931. Justice Trivedi has it?
Yes.
Yes. So just, I'm now not going to go into any detail. Just have a look at page 21. So you know, have a sense of the prayer. Please note, this is filed on 11th of October 2023. And it is mentioned in this court on 18th October 2023. 213931. Now the prayers that I seek are at page 21. I may be right, I may be wrong, but please see the prayers. Pass an order of stay of proceedings pending before the learned single judge. In writ petition WPA appellate site 1510 Rahul Chakrabarti, pass an order of stay of proceedings pending before the learned single judge in so and pass an order of stay of proceedings pending before the learned single judge.
But why do you want a stay of proceedings?
Yes, now I want a stay because it's really what is happening is absolutely chilling. I have set out those grounds I might indicate in para 23 onwards of this very application. That's on the major merits of the case. I can place that before you, or I can take you as to what happened there.
Tell us briefly what.
Yeah, so briefly what has happened is, I might just give you by way of background. I'll make it in very general terms and then get into the specifics. As I indicated to the court, there is an overreaching which is going on over here. So this court is passing certain directions. This court is, for example, this court is requiring the CBI to prepare a report and present a report to itself. Second, it is requiring, it's designating, I'm just giving you independently in the larger scheme of things, it's saying that, look, if there is an allegation of torture which has been made because someone was complaining about custodial torture in this court. So this court, the Chief Justice's court said, please go and make your complaint or whatever before the special court, the CBI special court. Despite this court passing that particular order, then the government comes over here and they says that no, this court has no jurisdiction. MA dismissed by the Supreme Court of India. So obviously the magistrate etc. proceeds because there's a complaint of custodial torture. The High Court dissents despite the Supreme Court of India's order. The High Court dissents and passes a blanket and a general order to the effect that CBI court, even though the special court, even though the Supreme Court has so directed, will not pass any orders without permission of the High Court. Now, that's a separate issue which your Lordship will look into separately in the leisure of time after replies, etc. are filed. But I'm giving you a broad sense of it. Now, go to para 23. Since you are asked, this is not directly concerned today, but I think your Lordship is absolutely entitled to know what my applications and apprehensions are. So, please go to page 19, para 23. I'm going to read 4 or 5 paras. It is submitted that as per the order of 18th October 2022 in Manik Bhattacharya, the CBI is required to file its report before this honorable court on 18th November 2020.
This
sorry.
petition is pending.
Sorry.
Which court this petition is pending?
This court. This main case.
Yes.
Manik Bhattacharya. Correct. That's why we are here.
He was the erstwhile president. He's in jail.
Yes, of course. So let me read on. It is submitted that as per he's the person to whom your Lordships have granted relief. But then whatever the protective orders were passed. Again, in respect of one agency.
In CBI.
Exactly. Correct. Delightful.
Today in custody.
Delightful. So much for our
Just
order.
a minute.
Yes.
Madam,
My lords.
you are for CBI.
No, my lords, actually, I am only marked for NIC in the first item, but I can get instructions if no one else is appearing, my lords. NIC is only the one who published the results, so we actually marked it as we are only formal parties here.
CBI is party here?
No, last time you remember your Lordship said that I should give advance notice. So I've given them advance notice and we are back over here now. And that's reflected in the office report as well.
Criminal matter.
coming up on Thursday.
No, Mr. Diwan,
Yes, yes.
what we are contemplating,
Yes, please.
matters are coming on Thursday.
Those are SSC matters.
Till then, we'll.
Yes, all right. Fair enough. Fair enough.
It's the same.
Yes, but and you may confine the protection only.
We wanted some instruction.
No problem.
Only to who are the applicants?
Yes, so the applicants are, respondents 39, 40 and 41. The individual officers are 40 and 41.
40 and where do we?
So this is
In 5.1.
Yeah,
Yeah.
5.1.
That is listed.
Well, I think the CBI has already interrogated on the same day. My
So
instruction.
that's fine. We'll protect them from
Yes.
What
arrest.
subject to your lordship's more kind consideration, what I say is this, my lord, the interrogation is on, it will proceed, my lord. Your lordship intent, yes.
We are not stalling the interrogation.
Yes, true.
That has to go on.
Correct. It will go on.
But let them not be arrested.
Yes, that's right.
Lord, this is not an anticipatory bail petition, my lord. The courts will not.
That's okay, but what kind of orders are being passed?
What kind of orders? I am going to, by next day, I am going to show how this person is committing criminal contempt.
Lord, if I want.
By overreaching Supreme Court of India orders.
I can also raise and pitch my voice, my lord. I don't want to do that.
Everyone can.
Yeah, I know, man. So I don't want to do that.
Normal pitch for Mr. Diwan.
So I have said some.
Fair enough.
I also go to this pitch, my lord, but I don't want to, my lord. What I say is this, my lord. CBI interrogates, my lord. Today, if they find something, my lord, then your lordship is my respectful submission. Leave it to the liberty of the CBI, my lord.
No.
Then your protection would be till the next day, my lord, till Thursday.
Who are the 1 minute applicant?
But the president, my lord, came, my lord, before the impugned order is passed. The impugned order is of September.
He has taken over charge only in 20.
August. But the impugned order, my lord, is of September. Because of September.
Oh, but to what extent?
That, my lord, I would have to give a reply, my lord. That I was.
To what extent any wrong can be attributed
We'll have
to him?
Lord, we don't know what documents he is hiding.
CBI.
Because the main man is inside. The main man is inside. So the documents would be lying with this current president only.
So that the documents they can go to the office and find out.
They should.
Stay in the
Correct.
investigation or interrogation.
Correct.
But no cause.
But what the learned single judge says, he gives liberty to the CBI. He doesn't say you arrest them. He said they are at liberty. So it should not be
CBI in any case is at liberty to arrest.
Your lordship may mention.
Why do you need a liberty from the court that you can arrest?
It was just mentioned below. It's not as if the judge said.
Where is the necessity of mentioning this also? Kindly
It's not as if the judge said go and arrest them. They said they are at liberty to act in accordance with law.
What is the necessity of doing it?
So that's what I'm saying. Well, once the investigating agency may not investigate, then they will act according to law.
Yes.
That's all. If they find the need to arrest them, one can't say don't arrest them.
Where is the necessity of prompting by the court?
Correct.
To have a power itself?
That is why I say, my lord, the only thing which can be done or should be done, my lord, subject to your lordship's kind consideration is, my lord, that once the interrogation takes place, my lord, then the CBI, my lord, will act in accordance with law. One can't curtail, my lord, and fetter the powers of the CBI.
Oh, see what? Now, who are the applicants? Where does their name appear? Oh, well, but Mr. Diwan, it should have been in their respective names.
That is so.
Because you are asking for an in personam order.
It is Mr. Dr. Gautam Pal.
Have you stated anywhere in the?
Yes, it's in the impugned order. It's in the order which we are seeking a stay. If your lordship has, it's I-8 222.
Mr. Diwan, Planet Senior Counsel for the applicant number 1, 2, and 3, and also Mr. Rahim appearing for the.
Lord, I am for respondents 1 to 23 in the main SLP.
Main respondent number 1 to 23.
Except R15. I'm not for R15.
1 to 14 and 16 to 23. In CA number 3212 hyphen 13 of 2023. On going through the materials disclosed, we direct that investigations so far as the applicants are concerned may continue to be conducted by the Central Bureau of Investigation, but until the next date of hearing of the instant civil appeal, they shall not be We'll tell him right now. You just hold a bit. Mr. Diman, you kindly ask your advocate on record to correct the cause title here and now.
I will do just.
All right. There is an error.
Name the
Yes.
president and
Carry it out with pen. They were pro forma respondents in the mail.
It's Mr.
Leave is
Gautam Park.
given.
You can give the names.
Leave is given
Yeah. All right.
to include the names of applicant number 2 and 3
Yes.
in the cause title, and the amendment to that effect may be carried on by the advocate on record of the said applicants here and now.
Grateful.
You do it.
Maybe give the names to the court master specifically. Yeah, give the name.
Normal, I'm sure in Bombay High Court also it
Yes, yes.
used to
yes,
be
correct.
corrected. And
We followed Calcutta.
Write it on the left side.
Reading.
you do.
In terms of court order dated.
Yes. So where is, these are all copies. Where is the main one? With affidavit?
that is in the section.
Acha. This shall be done in course of the day in the registry, but we proceed on the basis that such amendment has been incorporated.
Grateful.
This matter is supposed showing for
Yeah.
second. It can come up on Thursday together.
First applicant we are apprised is, what is his name? No,
Dr.
second applicant
Gautam Pal.
Dr. Gautam.
we are apprised is Gautam Pal,
Dr. Gautam.
Dr. Gautam Pal, and the third applicant is
Dr. Partha Karmakar.
Dr. Partha Karmakar.
Karmakar.
Stop. Yeah. So far as the directions of the High Court is concerned, contained in the order passed on
18th.
18th October 2023.
18th. Where is that?
You will find it at page 18 of 222598. It's a thin IA.
As far as the order of the learned single judge of the High Court on 18th October 2023 is concerned, we direct that the SIT may continue with investigation as directed, but
The CBI.
no, the order says, now what is SIT, what is CBI?
So here, my lord, the order doesn't say about SIT.
No, you come,
It's
page 21.
That's a new member in the SIT, but the CBI is also interrogating. So both can continue, my lord. But no courses steps if your lordship.
Yeah. CBI and the SIT may continue with their investigation as observed in the said order, which appears at page 18 of IA number 225598, taken out in connection with the same civil appeal, but they shall not be arrested until the next date of hearing of this batch of appeals and petitions. That is, next date of hearing of this batch of. We are order as it has been submitted before us by Mr. Diwan that Dr. Gautam Pal had joined as president of the organization
August 2020.
24th August.
on 24th August 2022 and Dr. Partho Kormakar. Is he a doctor too?
The order reflects the region order.
We have to check that.
And Dr. Partho Kormakar has joined the post of secretary of the board, deputy secretary
Shortly thereafter.
of the board.
Shortly
After
thereafter.
Dr. Gautam Pal had assumed office, charge of the office.
But both will continue to, Milord.
We've said investigation can continue.
Okay.
We don't need to give further handle.
So they continue to cooperate. That's all, Milord. They'll continue to cooperate. One line, Milord, if your Lordship put, Milord.
The High Court will ensure they continue to cooperate.
That's good.
Yes.
One word, one line from your Lordship, Milord, they will continue to cooperate.
don't
Otherwise,
need
Milord,
line.
sometimes they fall sick and they land up in the hospital for years.
I think falling sick in this city and several others is not necessarily voluntary.
Greatly obliged.
That is standard. Falling sick is standard.
Everybody, chief ministers, etc., they keep on. Greatly obliged.
Item 6.
Your Lordship. Your Lordship, letter has been circulated for this.
Adjourn as per later.
7.
Your Lordship, in item number 7, there is an MA move. Apparently, the order reflected an inordinate delay of 1343 days.
Yes.
Wide wish. So somehow it was an inadvertent error because the parties have come against the order of review, which is 24/11/2022, and the SLP was filed within 76 days.
No, they meets a case for review.
There was a case of review pending in the High Court.
So you must have challenged the original order and the office must have counted days from original order.
We have
You are counting from the date of order of review.
review because that is where
But you must have challenged the original order also.
I have challenged the order because
So therefore, there is no SL mistake.
then your Lordship, then can this review, because that I was pursuing my remedy before the High Court.
See, if you confine your challenge only to the
I'll confine that. I'll confine that. I'll because both are on the limitation. The petition was dismissed on the High Court.
Confine it, you will have to challenge the original also.
So, your Lordship, what has happened is original order, they dismissed the writ petition on the basis of delay. That there is an inordinate delay in approaching the SCAT, which is Central Administrative Tribunal, and therefore we are also not considering this. So, throughout the pendency of the list,
Right.
no merits have been discussed or
If you don't
deliberated.
challenge the original order, how can you challenge the order of review? Because you are not challenging the original, you are challenging only the review.
Your Lordship, I have to somehow come out of this rigmarole as to, because I was pursuing my remedy.
Yes, sir, there is no mistake in the order. There is a delay of 1343 days.
From the original order.
If you challenge, yes. If you are
From the
challenging.
original order.
So how this MA would be maintainable?
Then, your Lordship, can I submit that?
See, come to your application for condonation of delay.
Please, your Lordship.
Page 196.
Please, your Lordship.
Come to the prayer portion.
196. We have mentioned the review.
Condonation of delay.
Yes.
Only
I-
condonation of
That we have mentioned in this application also that it was an error on the part because we have in this
You are right.
your para 3 specifically says that however on 24/11/2022 the said review petition is dismissed without considering the fact.
That's a different thing that you explain the delay.
Please, your Lord.
But there is a delay of 1300 days.
See, again, you go up in para 6, you kindly see.
It is submitted that the delay of against the order dated 6/3/2019 is inadvertent and beyond the control.
Is a delay, how many days?
So from 19 it is there. 1-3.
No. So what is your own case? It is submitted the delay of 1343 days against the order.
Please, your Lordship.
So you ask for that and that ground Where is
Your
the-
Lordship, so then my prayer in this would be that it was an, I can't say that it was an error on in the application, but somehow the review petition, which got dismissed in 24.
Then you must have argued at the time of.
We haven't. There was some other AOR.
No,
That's
great.
not
That's
the-
not wrong.
But that is not even reflected in the order, Your Ladyship.
Sorry.
That is not reflected in the order that has been argued.
Can't keep on filing MS like this.
You're right, just one submission, because that would have been reflected in the order that
We don't reflect that, everything in the order.
Any case, we become functus officio. In some gross error, like name spelling, etc., we correct.
But perhaps
Section 152.
Perhaps
And such orders are passed in the open court. So the.
Perhaps, Your Ladyship, the one consideration is that we are, of course, the review was there. That is a fact which is staring us on the
We can
face.
now review over this order.
Dismiss this. We do not find any reason
Please,
to recall the order as asked for in this application. The present application is dismissed. Letter.
So this, I am for the respondent caveat, I had circulated an objection because the time period is too long, less 4 months.
How as a caveator,
Yes, ma'am.
you can object to the fresh moving of an petition.
Because they are keeping it pending in execution, they are.
They can
No, nobody knows. But they're using it. Because I'm only saying it, Lordship have a fixed date.
You have no right of audience.
I leave it on. But that's already pending, but they use this as a.
Caveator doesn't, till an interim order is contemplated, caveator doesn't have a right of audience.
Lordship, may give a fixed date if that I can request because
If he is not in a hurry, why are you?
I'm obliged.
Against my client, Your Lordship. First, the matter was filed for the eviction. Then, before the rent controller, the matter was dismissed, Your Lordship, because the facts stated by the respondent here in Your Lordship was not correct. They have misleaded the court that our client is tenant over there.
High Court has.
Better title, clear finding on fact.
You were permitted to.
Your Lordship, kindly see.
You have not paid the rent, nor you have.
Your Lordship.
Right to continue.
Your Lordship, I was never the tenant, Your Lordship. I was the adopted
Licensee, still.
I was the adopted son, Your Lordship.
No,
You kindly see.
She believed that you will take care of.
Yeah.
And but you misused her.
Trust.
Your Lordship, it was the. Your Lordship, kindly see page number 69, Your Lordship.
Nothing there.
What right you?
Also, kindly condone the delay, Your Lordship.
How many days?
71 days delay, Your Lordship.
Delay condone, petition.
Your Lordship is a very poor guy, Your Lordship. Mean profit has been 3,000 rupees. He's working in a shop. Kindly.
We can't interfere with.
Okay, highly obliged.
Problem.
Your Lordship, I'm appearing in item number 10.
There was an earlier challenge.
Exactly, Your Lordship.
Which was invalidated.
Your Lordship, so after that.
The Andhra Pradesh High Court judgment on this striking down the section 9. Then in
So Your Lordship,
Supreme Court.
Lordship, before I make out my case, it's only my duty to point out that there are multiple petitions which have been filed before this court challenging section 9 and the consequent relevant provisions of CPC, which is with respect to Order 21 and Rules 32 and 33 of CPC.
Right.
Now, in these petitions,
Fresh one. Whatever happens in that.
because Your Ladyship, I am right now concerned, I am seeking stay of the proceedings before the court who are telling me to appear before the court and go to the man with whom I don't want to live. Now, as of today, your leadership only
Forcing you.
your leadership.
Nobody can force you.
I'm only on the point of first disclosing.
He will be entitled to divorce after 2 years.
If I will be
He will be entitled to divorce.
the question which needs to be answered by the court is.
It can't be.
Your leadership, may I just
Decree.
the absolutely right, but the difficulty absolutely right, but the difficulty is that if I don't follow it, then my property gets attached. So essentially, if I don't subscribe to the policy of the state or whatever the judgment is, then my property will also be taken away, which is against my constitutional right with respect to property. In any event, before I open the case, it is my duty to point out that there are two orders passed by this honorable court. One is, your lordship, in writ petition.
What about that judgment by which that Andhra Pradesh decision was set aside?
So, your lordship,
by this court, why is that?
That judgment itself is under challenge.
What was the strength of the bench?
So, your lordship, for that reason,
what is that judgment? You show us.
That was a division bench. For that reason, these challenges have been referred to a 3-judge bench. There is a direction by the Honorable Chief Justice that all these matters would now be heard by 3 judges bench. So far as the subsequent writ petitions are concerned, there is one order which is being passed by 3 judges bench led by Honorable Chief Justice, that because it concerns with the same issue, therefore this matter has to be, it is only appropriate that this matter also gets tagged with those matters and all these matters get heard together. But therefore, all I am seeking is that this matter gets heard with those matters.
Refer a matter to a 3-judge bench, you must differ with the coordinate bench judgment. Where is that judgment?
Your Lordship, I'll just pass the orders.
Andhra Pradesh High Court judgment was delivered.
Wait. Please.
Not this one. This is a judgment by which that Andhra Pradesh decision was set aside.
The Andhra Pradesh decision was set aside.
Yes.
Your Lordship, so far as the point of validity of Section 9 is concerned, that is pending before this court.
No. There is one judgment by which there was a.
There was an earlier judgment which was passed, which is opposite, which is why now the challenge is before the 3-judge bench.
T. Sarita versus T. Venkata Subbaiah. That is the Andhra Pradesh High Court judgment.
This Sharida Qureshi versus Union of India.
83. AIR 83 AP.
Your Lordship, I'll just have a look at it.
Kindly have a look at it before rushing to court for
Your Lordship,
parliamentary act.
Your Lordship, as of today, Your Lordship, that judgment today in any
event, all the judgments. Judgment of
first you read the judgment
and the judgment of this court differing with the earlier judgment.
Your Lordship, all those judgments today stand to be overruled by virtue of
what judgment we want to know.
Your Lordship, I'll just enter across the judgments here. Your Lordship, we can just go through those judgments as well as the subsequent judgments.
When will you go through? You are now arguing the matter.
Your Lordship, so all those judgments, they stand to be overruled by categorical observations made by 9 judges bench in Puttaswamy. Subsequent to that in the stage, subsequent to that in 2 other constitutional matters and bench matters.
Has there been a direct overruling or you are asking for a constructive overruling?
Your Lordship, that is my submission and that is a submission.
First was the judgment which is overruled. You have
Your Lordship, that is mine. It's not been overruled. It's the challenge is pending. That's the submission there.
The judgment. You are arguing everything here. You have not prepared.
Your Lordship,
get that judgment.
We'll get a judgment.
Yes.
Your Lordship,
adjourned for 4 weeks. Before rushing to declare a.
Your Lordship, I am not carrying this particular judgment here, but I satisfy the conscience of this court from the next day.
Get that judgment.
What is the letter?
Letter. No preparation.
Later.
Where?
Later.
30.
To not interference 5 hours.
No. Restitution of conjugal rights.
Yes.
It was pending for final hearing before a bench presided by
Mr. Hegde.
Yeah.
There was the old judgment of Justice P.A. Chowdhury of Andhra Pradesh High Court.
Yes, that was Sarita.
That was set aside.
That was set aside by this court. Then
So
there was
what happened after that? Has it been reviewed?
No, there is a matter which is pending where this court has issued notice. It was to come up for final hearing before a bench of 3 judges. It was last before Justice Nariman's bench. It has not now come up. Anyway, I can give the details of the number. I'll give the number to your lordship courtmaster.
You must have all the judgments.
See, taking on a parliamentary act,
yes,
preparation should be there from the side of the lawyer.
Yes, my lords, I wasn't there in my learned friend.
And are you appearing in that?
I'm appearing in the matter which is pending before this court.
So let us see. We have adjourned. We have not.
I'll give the details of the matter if your lordship needs. I'll give it to your courtmaster.
Item 20, your lordship may kindly recall this matter in which your lordship issued notice. Then your lordship found that the cast title was defective. Therefore, your lordship dismissed it with the liberty to file me a fresh SLP. That's what my lord I thought. Your lordship issued notice after some time. Your lordship found that cast title was defective.
Cost title is amended.
Okay.
Now the cost title is amended.
New SLP. Your lordship gave me liberty to file fresh SLP. That I have filed.
Notice.
Grateful. Maybe state of commerce subject. They may proceed to pass final degree.
Nothing.
Very grateful.
So what is this leave to substitution application?
Mine suit for partition, preliminary degree has been passed. They may
no, it's not necessary, but you have to record that fact.
Which one?
Under order 22.
That you will also pass a detailed order.
In this matter?
In this matter only, you also will find it page 25A minutes. That you have a detailed order.
Right, but thereafter you must have filed
fresh SLP. You also gave me liberty. We accordingly dismiss the present petition with the leave to the legal representatives to file a fresh petition on the self grounds against same grounds against the same order which is sought to be assailed in this petition.
So those people.
But did you file IA for substitution also?
Substitution.
That's what they say, that some IA is pending.
I need not file substitution because my father died after the judgment. And I file it directly. Anybody can file SLP.
After the judgment.
That proper course would have been that this IA should have been placed before the registry.
May not require, Madam, Order 21, Rule 7. But I
They
can
have
file.
permitted you to file after.
Straight away I can file. After, if suppose my death was after the judgment, but before I file SLP, I can straight away file it.
Okay.
Straight.
But IA, there's no need of IA. We have already, but which IA is this?
There are permission.
Why have you asked for an application for setting aside abatement in that event? There's no abatement.
There's no abatement now. No abundant caution, not I have done that.
What abundant caution? On implication of mine. So this is, application is misconceived. Shall you withdraw these two applications?
Legal substitution application also
See,
I file Mirror.
Will grant this leave to the legal heirs?
Abatement won't come.
Which date was that?
That date, 4/9/2023. Page 25A.
In view of our order passed on 4th September 2023 in SLPC diary number 28616 of 2023, we grant leave to the legal representatives of deceased Murugesan to file this petition for special leave to appeal. In view of this order, IA number 221241. Now, in view of this order, Mr. Nagamuthu does not want to press IA number 221241 of 23 and IA number 22143.
May say that they are not unnecessary. Not kindly say that if the court order saying that it is unnecessary.
That's what, in view of this order, does not want to press these two IAs.
It will go as though I have withdrawn. It will go as though I have withdrawn. You will ask me kindly.
So these two IAs are dismissed as withdrawn.
But as unnecessary, you will ask me kindly say.
Dismissed as withdrawn as these are misconceived. Then that condonation of delay in filing application, that will go also. IA number 221244 of 2023 shall also stand dismissed. Because you are not asking for setting aside abatement, because abatement really never took place.
Great. Very good.
Take a training of Order 22.
Yes.
Take a class of the advocates on record.
I wanted to argue the Order 21 Rule 7 of these High Court rules. I wanted to say that I got right not to file it.
Yes.
If the Lordship wants me, I will argue elaborately. Lordship, kindly take it up at the end. Right now, I do not have the materials in my hands because it is dismissed. I will not come.
No, but you are saying this order is contrary to some rules of this court.
Yes, Order 21 Rule 7.
Yes, what does it say?
Supreme Court rules, before
PC.
Before filing, if a party dies, Order 21 Rule 7.
Yes, Order 21. Yes, what does it say?
SLP, before filing, if a party dies, what should be done? Order 22 Rule 7.
Order 21 of the Supreme Court rules.
Rule 7.
Order 21, Rule 7.
Yes. Where any person is sought to be included in the petition, the legal representative of any party to proceed in the court below, the petition shall contain notice.
Yes.
Yes.
That's what basically what you've directed. See, this expression where any person is sought to be implicated is possibly not the appropriate one. Because this is to bring an action.
Rule 8, where at any time between the filing of the petition for special leave to appeal and the hearing thereof and becomes defective.
This is after filing of the petition.
Proceedings in the court below. None of them.
There is no other permission.
Right.
But you tell us. We'd be happy if you point out some error on our part, but we could.
We'll have to take it as a last matter, because I will bring all the books.
Yes.
Your Lordship could permit me to argue the matter at the end of the board. I will do that.
No. We have issued a notice in your matter.
Yes, this is what.
But in a situation of this nature,
Yes.
where after judgment is delivered, but before SLP file, the party dies. Then then substitution question
doesn't arise. He can say to any third party.
Permission to leave to file affidavit leave to file SLP becomes necessary, because our rule says that unless you are a party, you cannot.
Let's say order of the Honorable High Court, whether it is a civil court decree or anything, can be challenged even by a third party. But I have to take permission.
No, third party also leave is necessary.
Anybody, SLP, because I am speaking only.
So here as legatees or legal heirs of the deceased,
they can file.
They can file with the permission.
Yes, that's all.
So that's
what we substituted first with the permission of the
permission.
Then they can file, not otherwise.
Yeah.
Otherwise, how court would know? You have to file some affidavit and
permission is required.
That he has signed on such and such date in between this period.
Correct.
And therefore.
So that is the order of this 1st September. But in a later case,
I'm not saying anything about that order.
If you think we are wrong, you kindly tell us. Show us the rules.
That's in the Madras High Court, the wrong procedure was being followed for about 30 years. Then, kindly permit me to say this much on that. Then we issued a notice to the entire bar. The matter was fully heard on this issue. Then I passed an order that is being followed today. In 30 years, what was being wrongly?
So what was the order?
The order was, suppose during pendency of a second appeal, a party dies. No application for setting aside the abatement, no application to condone the delay in the matter of abatement, no application to bring on record LR or file. Straight away, one application was filed. There was practice, long practice. Practice was to amend the cause title. They will simply. But that was based on a division bench judgment that was long before it was delivered. That was a case where we found out that was a case where today I present a second appeal. I do not know. Yesterday the defendant died, so I filed it today. Today I filed it. In that case, on the date when it was filed against a dead person. It's not a valid presentation. Yes. In that situation, the court said, for no fault of mine, the appeal need not be rejected, leaving it open for you to file another appeal. Instead of that, you please simply amend the cause title.
Possibly
that's on a different context.
Yes.
So far as this is concerned, you will fully agree with your Lordship. Very grateful.
I don't agree with this.
Why are you coming up in appeal? It's a one-off situation.
The short question that arises without the consideration that the back wages will be automatic.
Normally, back wages should not be given or not, but
Lordship say when high
one-off situation will keep the point of law open.
Lordship will then keep the point of law open.
Yes.
Just observe.
Petition is dismissed, but point of law is kept open.
I'm good. Please, Lordship.
Lord, out of two judgments, the judgment of the trial court, who's the person?
Notice 3 weeks return.
I'm obliged.
16.
Letter.
Is the letter circulated? 17, 16. It's a letter.
She's saying better.
Oh. 17, we haven't received any letter.
17. Item number 17, I'm for petition.
Yes.
My lord, there are certain crooks in this matter. First of all, there is a violation of Punjab Police Rules 16.38, 1 and 2. The sanction from the district magistrate was not sought by the SSP to initiate domestic inquiry or departmental inquiry. Secondly,
in departmental appeal, the increment has been reduced to 2.
Sorry,
The punishment has been reduced to 2 increments, stoppage of 2 increment.
yes, it has been reduced.
Against which you filed suit, that was dismissed. First appeal, second appeal, everything is dismissed.
Yes.
So what remains?
But in departmental inquiry, the issue was not created. The issue which was framed that says that the petitioner has not served notice under section 160 of CRPC to the suspect.
Now, it's only question of punishment. Punishment has already been taken care of by the appellate authority. Then you file suit, dismissed. First appeal dismissed, second appeal dismissed.
Dismissed.
80.
Country pass the government. Arguing consideration or her own leg another both.
Who?
Miss Anita Shenor.
After vacation, accommodation is asked for on behalf of the petitioner. Least after vacation.
90.
Please, my lords. Dear my lords, when I applied for the job, it was not a tenured post. My lords, the advertisement as well as the appointment letter says that it will be pensionable, that I will be on probation for 2 years, and then thereafter it was confirmed. The rules come in 2000. My lords, 2000 there are two batches, 2006 and 2008. The rules come in 2014. Now what the division bench has done.
That advertisement was for contractual appointment.
No. Those were for regular appointments. I'll point out, my lords. If your lordship sees the appointment letter itself at page 87, paragraph 2.
Page 87.
Yes, paragraph 2. That's a sample appointment.
Appointment will be on permanent
And
post. Will be temporary.
During the probation period of 2 years.
Adjusted in regular service only if.
Yes, there is no problem about my conduct. No problem about. In 2014, subsequently rules came in. And they were sought to be retrospectively applied. I said it can't be retrospectively applied, at least in our cases. There, my lords, unfortunately, the High Court, in another matter of a temporary employee, I'll show your lordships at page 190.
Normally, Mr. Higre, rules can be retrospectively applied unless you show some vested right.
Yes, but here the right is vested. Your lordship sees the appointment letter itself. And 2008, 6 years later.
Notice.
Please, my lord, status quo because I'm still in service.
No, you terminating your.
Your lordship may only say that I need the
status to be regularized.
Yes, but
nothing will happen.
I'll take Dasti, I'll serve, etc., etc.
Notice Dasti. Yes.
Return.
Returnable after 4 weeks.
Grateful.
20.
Please, Malak, item 20 minutes.
Alternative remedies available.
There is an alternate remedy that is. We've already crossed the threshold minutes. Now, let's kindly can I just pass on these sections?
Election petition.
The limitation is there, 30 days limitation. As and when I got the information, let's consider this, minutes. As and when I got information, minutes, I wrote a letter, a complaint to the election officer.
The statute says this is the limitation you have.
That is absolutely right, minutes. In similar matter, in similar matter, the Honorable High Court has accepted and admitted a petition whereby the district election officer has rejected the voters.
We don't know, at least in this thing.
Let's then let's I have a small request, minutes. Then the limitation of 30 days may not come in with minutes. I'll approach that's the old problem, minutes. Because as and when I got the information about the results, minutes, I approached the authorities, minutes.
You should have been more vigilant.
It's only after the results, minutes, I got to know, minutes. Otherwise, if Manoj would see my complaint before the officer,
Sir, you had 30 days. What did you do?
it was only after the RTI, after the RTI information I received, I immediately moved to the High Court.
Next matter.
Wait for this.
What's this? Wheels.
21, I think.
Yes, madam.
Can't hear you.
It looks like similar matters have been.
So it appears to be the
Yes, madam. You are not audible. We are not.
We can't hear you.
Still, we can't hear you.
Your Lordship, may kindly pass over, Your Lordship, in case I'm not audible.
Now you are.
Okay. Your Lordship, in this particular case, we had sought amendment of the plaint, Your Lordship, with regards to the point that.
What is the stage of suit? At what stage did you ask for?
Your Lordship, this is to be very fairly stating in bar, Your Lordship, this is at the fag end, Your Lordship, in a sense that the arguments have also been concluded.
You have to be fair.
Indeed, Your Lordship, I am bound by the facts, Your Lordship.
Dismissed. Sorry, dismissed.
Much obliged, Your Lordships.
22.
Please go ahead. Well, the AOR is on, she's appearing virtually.
Please, my lords. My lords, at the onset, apologies for not being able to present physically before my lords. I'm on maternity, advanced maternity. My colleague is there to assist my lords.
Okay.
A typical case where a senior citizen is running from pillar to post to put things in order in the cooperative society, my lords. For 13-14 years, there has been no election. As per the act, if the...
Now the new board shall take steps.
Please, my lords.
Your party have directed the new board to take steps. So the
my lords, the special officer was never appointed as per the
interest of the society. Right? Who are you?
I'm a member of the society, my lords. I own a flat.
The commission to take steps, but commission did not have the jurisdiction. So now the new board shall take steps and take care of the interest of the society.
Yes, my lords. But the new board is also not elected properly, my lords. Not as per the act.
New board is elected.
Officer that has been appointed.
If new board is not appointed properly, you go before
the appropriate remedies.
The petitioner has filed, my lords, two writ petitions.
Your petition will give you liberty to apply before the appropriate forum.
My lords, we have written numerous letters to the appropriate forum, my lords.
But if they don't act, then you have to.
But in the order also, there are wrong recordings, wrong submission.
Either you or you.
We do not
in the order, my lords, even only based on oral submissions, they have passed a blanket order. The High Court Honorable High Court has passed a blanket order.
Then you ask for a review.
Based on oral submissions.
The present petition is dismissed, giving liberty to the petitioner to apply before the appropriate forum.
Please, my lords. Grateful.
That is the proper course. Why are you coming to the Supreme Court?
Petitioner has written numerous letters to the appropriate forum, my lords. That's
yes.
And then we filed the petition subsequent twice. And a blanket order has been passed, my lords.
The new board is already constituted, so it will
if the new board, you can go to the registrar. Possibly there's a dispute resolution clause.
We have written to the registrar, my lords. So I can show you, my lords, if you may please bear with me. Because it has not happened, and re-audit and re-inquiry in the matter is required immediately.
We're giving you liberty to.
Please, grateful.
I beg to appear for the petitioner. There are two issues, my lord. When once a person has renounced the world, would not the property right, my lord, divest and vest with the family? Can there be a divesting if he, my lord, subsequently chooses to, my lord, embrace the material world? That is the one substantial.
He renounced the material world after marriage.
Even after marriage, there is no, my lord, so far as wife is concerned, there is no right in the family property till
No. Wife has a right of maintenance.
That's all. Therefore, so far as the share in the joint family properties are concerned, my lord, the shares will have to be recalculated.
How has he renounced?
Even his own admitted case is that he has taken up sannyasa in the plain.
Every sannyasi does not renounce the world. Ramakrishna Paramahamsa.
No. My lord, that's the only issue, my lord. Every sannyasi, my lord, renounced the world. That's the law.
Not necessarily.
My lord, that's the law here, my lord, in southern India. There is no concept of a sannyasi having a, my lord, material world. That's the only issue involved in this case. So far as wife is concerned, that's the only issue, my lord. The other issue is, so far as item number 1 was concerned, there was a compromise, my lord, way back in the year 1970.
We are issuing notice.
Obliged, my lord. The status quo may kindly be, my lord.
No status quo.
All right.
24.
There is a letter.
All the three courts.
Concurrent findings of the
Concurrent findings of all the three courts are against me, my lord.
Dismissed.
26.
May it please, minutes. Minutes, I file an election petition before the Honorable High Court of Telangana against the respondent. Minutes, it was dismissed. My last may kindly come to page 7, where the issues have been cast and then the answers were given. One of that is, minutes, minutes, returnable. If you launches, please.
4 weeks.
Can I take Dusty on initially? Dusty. Great. Deeply obliged, minutes. Great.
7.
EW1 is a charge witness brother. Testimony is fairly clear. Some lapses in investigation. Trial court convicts based on that. High court is overturned. I would request this matter will need to be considered. It's entirely hinges on PW1. Broad daylight murder. He's identified the accused. I'm sorry?
Notice.
Notice. Permission to file SLP.
Permission to file.
Grateful.
This case is covered by this court's judgment in this.
But only problem here is DNA was found negative.
No, DNA initially FSL was report was found positive. Kindly see the first order, and DNA was not found. It was not a, what you call, the sample was not found sufficient for conducting a DNA test.
Did you put that?
Yeah, kindly see that in the order itself. The first one, Your Lordship, may see at page first order, Your Lordship.
Bail. Granting of bail, and he has been in jail for more than 1 year.
No, Your Lordship, this mandatory provision has been violated. There is judgment of this court. It's a nullity. The order is judgment by Honorable Chief Justice. Even if it was a third bail application, the notice was mandatory. And she had not been
You
heard.
were not served with the complainant was not served
Not
with
served.
notice.
That is the case.
Notice.
I've also paid for interim relief. Lordship,
Interim relief means sending him back.
But I just
They will get a final.
just okay, Lordship.
Yes.
For this, for the satisfaction of the client, we have to write something. So, yes.
You may write, but you need not speak. You need not speak.
Sometimes you should advise your client also that what can be achieved legally and what can.
Client will run away. In that case.
Client runs away, let him run away.
Lords, in 1929, this is a case of pure circumstantial evidence, completely circumstantial. Even the sole.
Concurrent findings are there.
My lords, if I may just show this, this is sole circumstantial evidence. What has happened is that the informant says that my father went to the accused's house. He did not see that. My wife told me my father went to the accused's house. When I came back home, I was told by PW2, who was told by PW7, who was told by PW4 that my father was murdered by the accused. Now, this PW4, who is the only alleged eyewitness, if my lords may see the testimony, has turned hostile. He says that this never happened. There is no direct evidence. There is no recovery. In fact, my lords may note that the doctor says that the murder happened by strangulation. Later, the alleged axe is shown to him 4 days later. He says this could have caused one of the injuries. This could have caused the death. But that axe, he admits, is not bloodstained. What is recovered is a bloodstained axe.
Doctor cannot be 100% sure on cause of death.
I bow down, my lords. But my lords may just see the way in which the investigation is done, the way in which the order is. I just want to show my lords 3 things. If I may just
show us the deposition of this eyewitness who turned out.
Yes, PW4, my lords. That is at page number 38. This is Balram, PW4. May I read? Examination in chief. I know the accused presently. 38, my lords. Yes, 38.
38 is PW3.
Sorry, P39. PW4. My mistake. Page 39. I know the accused present before the court and also know Nanki Nishad, who has died. The incident is of 3-4 months back. I do not know anything about the incident. Police has interrogated me. At this stage, the additional prosecutor has stated that the witness is hostile and the prosecution seeks permission to ask leading questions. 2. I know Poonam Srinivas of the village and Kotwar Rmpssu.
His 161 statement was not exhibited.
No, it was not. I'll have to check that. It's a legal aid case. I wasn't given this 161 statement. And in fact,
whether it was made an exhibit or not.
No, my lords, it was not. In fact, the list of exhibits does not have that. And he never even told the police that. That is the whole point. Because the informant...
So, what is the foundation of
My lords may have page 6. That's where the impugned order starts. Page 10 is the analysis.
No. Impugned order is not very elaborate. But you have to see the...
Very well. Lords, in fact, the trial court judgment, what they do is he does not even, the learned judge, in my respectful submission, does not even examine each evidence.
Where is the trial court judgment?
Yes, my lords. It starts at page number 51. He frames at para 8, page 52, there are 8 questions that are framed. Whether on the day of 13/8/2012, in the middle of 12:30 to 5:30, the accused assaulted Nankiram Nishad with an axe.
What does your implication in this offense transpire from this judgment?
So my implication is that I am the person who has killed him.
Where is that been dealt with?
Yes, my lords. So in fact, my lords, it is very difficult to even get that out of the judgment because he has not actually analyzed. There is no specific analysis of the role of the accused. The accused was not even last seen. If in a case of circumstantial evidence, at least the accused has to be last seen with the deceased. He is not last seen with the deceased. There is his wife who is last seen by the wife of the informant with the deceased. In fact, after that, we don't even know if the deceased actually went to the house of the accused. The body of the deceased is not discovered in the house of the accused. It is discovered near the house. The alleged, in fact, it is the first opinion is...
Notice.
Grateful, but he's been in jail for 13 years.
Issue notice, let original records be produced and copies thereof be given And what's the soft copies thereof be made available to the Learned Council for the parties.
I'm very grateful. Milords, he's been in jail for 13 years now. Issue notice on interim.
We are not inclined to issue notice. You have persuaded us.
Milords, delay may be condoned. It's a legal aid.
Yes.
Delay, legal aid case.
Delay condom. Yes, delay condom.
I'm very.
See, the 62.
Because there's a letter circulated as well.
Later. Not as per letter, both.
Both.
51.
Lords, we are seeking statutory bail as the charge sheet file was without the FSL report.
No, there is no that.
Judgment on that possible.
Yeah. Merely because FSL report was not produced, that doesn't mean the charge sheet was incomplete.
It was not filed also. It was the charge
It was
sheet.
filed on 10th March.
My lords, that's my mistake. It was actually filed on 10th of August. I have the order of the.
Merely because the FSL report is not there, doesn't mean that charge sheet was incomplete.
The same issue is being considered by the larger bench. My lord, may I refer to
Okay,
the order?
it's considered, but no decision given.
My lord, may I just have this order? Please just have this order because the same issue is being considered by the larger bench.
It's been considered, but has any verdict come?
Yes, can I just show these two orders? Just have this order. Just have a look at the same issue.
That doesn't mean that charge sheet.
Just consider this order. I'll just refer to that because this is what has happened, and many people have been given bail on the basis of this.
These are all interesting.
This is the primary question sought to be urged in the instant petition is with regard to the petitioner having acquired a right to seek for statutory bail since the charge sheet file is without the FSL report. The aspect of the matter at this juncture need not be gone into since the said issue is pending consideration in a batch.
Sorry, we are not dismissed.
Then may I withdraw this.
You should have withdrawn earlier. She tried. Withdrawn, dismissed as withdrawn.
But the liberty to approach
No more. Dismissed. At this stage, we can say. Then we'll simply sit and dismiss at this stage.
My lords, may the notice be issued and tagged with
No.
We are not agreeable.
Dismissed at this stage.
But my lords, this issue is being considered by the larger bench. Like what?
Yeah. So
what is different? How are we different?
As and when considered, we'll see. At present, we are not agreeing to this.
Consideration for almost 8 years out of 10 years.
You have been granted interim bail.
Interim bail for 4 months, Your Ladyship, and I have surrendered within the time.
Have you surrendered?
Huh?
Surrendered back?
Yes, surrendered back.
What is the surrender certificate?
Page number 66, custody certificate is there, Your Lordship.
So the appeal is pending before the
High Court.
High Court. So
Yes,
let the appeal be-
since 2016 it is pending.
Right.
And even in the impugn order, they themselves have.
Request the High Court. We dismiss the present petition with a request to the High Court to hear out the appeal of the petitioner expeditiously.
Within some time frame.
We don't give time frame to it.
53.
Much obliged.
May please, my lord. My lord, pure civil disputes, my lord, but arising out of 2 memorandum of understanding, my lord, executed between the petitioner herein and the first informant. Now, my lord, the allegations are, my lord.
Finding is FIR constitutes.
Not at all, my lord. Just have 298, my lord. 246. The allegations in the FIR, my lords, are regarding the running of this company, my lords, called Saroj Realtors. Now, my lords, allegations essentially are of operation and mismanagement. Just have page 246, my lords. Brief facts, your lordship will have.
You did not deposit the amount.
No, they were to bring in the amount, my lord. The amount was to be brought in by them. They brought in only 10,000, my lord, out of the assured amount of 2.5 crores. Now, please have straight away come to 240.
What stage is the proceeding?
The proceeding, my lords, the charge sheet has been filed. My case for quashing was pending, my lords. So just have page 248, my lords. There's something turns on this, my lords. 248, these allegations from 247 onwards, my last paragraph.
Now he apprehends that this is the first informant, madam, that the said Abhishek Chaudhary, who is the accused, madam, petitioner before your lordship, Shikha Talukdar and Meena Kumari Das may remove them from the directorship, shareholdership of the company, which along with Sheetal Jain are holding as on date. Since Abhishek Chaudhary is the director holding the digital signature certificate, he may utilize the DSC with undue advantage for his own benefit, causing irreparable damages, which he thinks should be seized immediately. Now, regarding these allegations, he has moved the Company Law Board, Calcutta, and Calcutta order is at page 89. Just have that order, madam. Page 89 at 96. These CLB proceedings are initiated simultaneously with the filing of the FIR. At page 89, madam. CLB Calcutta, madam. Under 397, 398 at page 96. Straight away come to the direction at page 96, madam. Grants them the interim relief. That interim relief is still continuing proceedings before a CLB are pending. Just at page 96, madam. After looking into the aforesaid submission of learned, my lords, has that of the petitioners, I am of the considered opinion that there is prima facie case of prejudice against the interest of the petitioners, and accordingly, interim order is hereby passed, directing the respondents to maintain status quo with regard to the shareholding pattern as well as the composition of the board of directors of the company until further orders.
Was it shown to the High Court?
Because all this was placed before the High Court. High Court just had the High Court order, madam, with respect.
These are all your defense.
No, madam. Point today is proceedings in CLB are pending. Not me. They were to bring in. They were to bring in the money, pump in the money into the company. Now, madam, please have straight away page 4. Now, madam, civil suits inter se between the parties are pending. NCLT proceedings which the other side initiated was dismissed, upheld up till the Supreme Court the dismissal, madam. These are pure civil disputes, madam.
That's enough. I think it doesn't meet the exception to Bhajanlal dismissal.
But here civil disputes otherwise, madam. It requires consideration.
Many civil disputes.
But may I say this, madam? There are today, madam, between the parties 2 inter se FIRs, madam. One registered by us, their charge sheet has been filed. One registered by them, charge sheet has been filed. Well, your lordship notice when, madam, let them send for mediation, madam. We'll try and work out something, madam. Something your lordship.
We can send for mediation. Yes, next matter.
Well, may I say this then, madam? So the observations made, madam, everything, all contentions be left open, madam, for the purposes of charge.
Dismissed.
The lordship will just say that because High Court says prima facie.
Yeah, apply for
discharge
in the event charges are framed.
At
the charge framing stage.
And all contentions are kept open, madam, because High Court
That's
says.
implicit.
No, High Court says prima facie offence is made out.
Prima facie means it's kept open.
But for charges, my lords, even great suspicion is enough, my lords knows that, madam. So just that clarification will help me, my lord.
As such, after dismissal of coughing, discharge also should not be permitted. You will have second round.
No, my lords. My lords, on the material,
You go for discharge or you go for caution.
But otherwise,
After caution is dismissed, you go for discharge.
but otherwise, my lord, on the materials available before the trial court, my lord.
You should have gone for.
Yes, next matter.
Lords will just clarify that, my lord, contentions are kept open, my lord.
It's obviously kept open.
But Lords will say that, my lord, that will help us, my lord.
No, it's unnecessary. It's just purely surplusage.
When we are dismissing, naturally we are not satisfied.
Please. Again, a pure civil transaction.
Only someone.
The issue is this, Miller. This is not a curable defect. They have not produced any evidence to satisfy the magistrate. Now the High Court, by garb of this, Miller, they're sending back so that they can produce all evidence, and now whatever they have to do.
Whatever, this isn't interfere. Dismissed.
Like that.
This kind of matter should come to this court.
Greatest respect, Miller, this is against the judgments of this.
That's the thing. Yes. 35. Anyone appearing? None appears. Then the matter is called on, adjourned for 6 weeks.
I beg to appear for the petition, Miller. This is the case is based on circumstantial evidence, Miller. The petitioner is accused number 3, Miller.
Number 1, Rupa's SLP has been dismissed.
Right, because she was not.
I am appearing in that matter. There are 2 SLPs. One is for the husband and the wife.
So far as Rupa is concerned, accused number 2 says
That has been dismissed.
that has been dismissed because he has now surrendered.
Huh.
So far as the husband is concerned, I was convicted for 102 and 7 years.
201.
No, 201 and 7 years, and I have been exempted from surrender. So far as accused number 2 Rupa is concerned, SLP has been dismissed.
You are Malek or?
I'm Malek, husband of the Rupa.
Huh. So you have been convicted only for 201?
Yeah, 201, and for 7 years is the sentence.
Even one circumstance is not proved by the prosecution. Right? PW7 is the only witness. PW witness is not supported. Look at page 130.
Where is your wife?
The wife, I have no.
You have no idea.
Dismissed. So far as accused number 1 is concerned, Malaysia is concerned, I want to one judgment.
Accused number 3, well, altogether different.
I have no.
But I want to make pre-submission. Kindly consider. There is no even one circumstance not proved by the prosecution against accused number 3 is concerned. But only accused number 1 and 2 is concerned. Here's the evidence. PW7 is the witness, the last scene is concerned. PW7 turned hostage. Even PW7 and PW8 specifically say that they have never seen on 19 to 2015. The incident was took place on 5:15 p.m. They specifically said at page 113, the evidence is where I produced it. Kindly look at page 113, 113. This is the only one evidence.
Messages were also sent to you.
Sorry, madam.
The messages were sent to you.
The message may not. I produced the message also. Message that does not contain anything. But it's a 4/2/2015. The incident took place on 19/2015, madam. 19/2015. Page 113, the PW7. Only the one witness, the last scene here is concerned. Kindly look at page 113. But 114 specifically said that this accused number 3 was not present at the time of accident. 114. This is the only one evidence. No other circumstance held against me. Even the DW1, the headmaster of my school, Pragati school, was examined. He says that he was 19/2015. He was in a school. He was discharging his duties in school.
But you and he both were involved as such. Why he has been not convicted for 302?
Well, because my role, you will also can see the page 45 of the impugned judgment at 47. I was not there in the place of occurrence. And my role is only that they say that because she is my wife, I might have supported and not informed to the police. That is what they say. But in fact, it has come on record. I am the first person to inform the police. I took the child to the hospital. I called the ambulance. It has all come in the evidence. And you'll also kindly turn to page number 45 of the impugned judgment, madam. So far as role played by the Malaysian husband, 47. In second matter, I am in SLP number. In second.
You were absconding and you were defending.
No, I am not absconding. In fact, I am not absconding.
As the petitioner is concerned, but immediately surrendered. He was in custody since forward.
You'll also kindly see my SLP number 4150 4151 of 20. Second petition.
His wife is absconding.
My wife was absconding, and I'm in this because every husband is under the control of the wife. The wife. Why should I be punished for that? Lastly, kindly see page 47 for the impugned judgment. Page 45, paragraph 47. What is the role of the my 47 married man? Admittedly, accused number 1 is the Malaysian husband.
Accused number 1 is Rupa.
No, madam. Accused number 1 is Malaysian in the charge sheet. So, admittedly, married man. Admittedly, accused number 1 is one of the teacher who was running the school in question along with accused number 2. He had the care and custody of the children who were studying in the said school, including those children who were also studying in the school. Being a de facto guardian of the children, he had a greater responsibility to take care of their safety and well-being. Immediately after coming to know about the unfortunate fate of the child, instead of informing the police and also the parents and disclosing the true fact, he has joined hands with accused number 2 and 3, and he removed the dead body from the noose and tried to destroy evidence by concealing the plastic thread used for hanging the child. He has also joined hands with accused number 2 in misleading the parents and other relatives of the deceased. In this way, he has acted in concerned manner with accused number 2 and 3 and has started a common intention with them.
Your role is very specific.
The space, last can you see 48? The suspicious conduct of accused number 1 was subsequent to the incident also support a case of the prosecution.
Sorry.
But I have to make a submission that number 3 is concerned.
No further submission.
But PW8 even specifically murdered.
One
circumstantial evidence. One of the even one circumstance is not held against him.
The 2 children, 4 years and 9 years, that's
Dismissed.
why the exemption was granted to me. Now both the husband and wife behind the bar, it is very harsh case. I have no roles at all. I was not there in the present in the scene of occurrence. Exemption order, why it was granted?
Taken in 106 also.
106 is concerned.
106 concern is not me.
106 is also not applicable where case number 3 is concerned. Right? He was not even the two witnesses, PW8 and PW7 specifically said he was not there in the incident. Right? So 106 is not to track me to explain that what happened in the school. Right? I was working in a altogether different school in Pragati school, 20 kilometers away from the incident. This is the incident happening in the Shantinikeshan coaching center, 20 kilometers away from it. My headmaster was examined. I was very much in school in 19 to 2015, at 5:15 p.m. I was nowhere in the picture. It was when the police informed the PW1, based on the warrant statement of the accused number 2, the accused number 3 was implicated. No circumstance against me. There's no circumstance. Where I just look at DW1 evidence, specifically said that he was working on 19 to 2015. Can you look at it for a moment? There is no evidence against accused number 3 is concerned.
Accused number 3 is Sanju.
Sanju, even actually even the High Court and Trial Court is not dealt with independently my case. Only at paragraph page 80 is only discussed about PW7. The PW evidence is not completely extracted in the impugn order. But DW1 evidence.
Health produced. Health produced this evidence. PW8.
PW1 I produced at page.
PW8 you said.
PW8 at PW7 at 113. 113. PW7 is a very crucial witness. She said that she has seen on 19 to 2015 at 5:15 p.m. But she specifically said at page 114. 114. I learned the feature so and so. Police had summoned me on the same day, made inquiries. After our days, once again, I was called the police station. On that day, police were not in the station. I have stated about the aspect which I am deposing. The third accused, the petitioner, who is now before the court, was not seen me earlier. I had not stated anything about him in the police. Specifically, this is the only one piece of evidence against me. But there is no other evidence is available.
Turned hostile.
Turned hostile at PW8 at page 118. Again, PW8 neighbor.
She has been permitted to
cross-examine the PP. But this is the only piece of evidence, she was not supported. At PW8, kindly look at PW8 116. 116 at page 118 specifically. Got it 118.
See, para 46.
Please, madam.
The judgment.
Yes, madam.
High Court.
Yes, the incident had taken place in the privacy of accused 1 and 2 and no third person was present. This information is within the knowledge of accused number 2 and 3. The burden is on accused number 2 and 3 to explain what exactly transpired resulting in the death.
PW7 said that she was not there. Even PW8 also said that he was not there.
1 and 2 have denied knowing accused number 3. Now there are some phone calls.
The SIM was collected.
Yes.
SIM was collected. The message was sent in 4/2/2015. 4/2/2015. Incident took place on 19/2/2015. But the 4/2/2015 to 9/2/2015, there is no messages. There is no messages. Even the IO is admitted that the mobile belongs to whom also not come into picture.
Persuaded us in SLP criminal 3709 of 2022, we are issuing notice.
Milord,
The other one we are dismissing.
Milord, so far as the
No,
husband
no.
is concerned, Milord,
There are material
it's
against.
a matter where
There are materials against you. Yes.
Milord,
Next matter.
Milord, the whole allegation is that they had an illegitimate relationship and this incident has happened. So, Milord,
see.
it requires consideration. Even the Lordship are issuing notice. Lordship, kindly see, I have
In
my
Sanju only.
In Sanju only.
Milord, the accused number 1. I'm not asking anything for the accused number 2. I'm only concerned about accused number
No,
1,
no.
the husband.
We are not.
The husband is not a party to this
Next matter.
entire incident. As he was not present at the place of incident.
Sorry. Yes.
37,
37. Letter.
38.
Your Lordships, a letter has been circulated.
Letter.
38, if you can kindly be given a specific date of 20th November, Your Lordship.
We'll see when it comes.
39 also letter has been circulated.
39 letters.
40 plus 63.
May it please. So the impugned order in 40 and 63 is the same.
63. You are there.
But they are seeking an enhancement of the maintenance bills, and I am requesting for the divorce decree bills. Because my monthly income is 22,000. Their monthly, her monthly.
What do you do?
Well, I have a cloth business. He claims that I'm a director. My even DIN number is not active. I have filed income tax returns for the last 5 years. Not more than 25,000 in any year.
22,000.
This maintenance aspect.
Maintenance will go.
And with regard to my petition, would your lordship be inclined to issue notice on that?
No, it was.
I've for the last 11 years. I am a husband, Milord. Item 40 is my SLP. Item 63 is the wife's SLP.
You are against granting of maintenance.
No, divorce has been denied. For the last 11 years, we have not been staying together. She stays in Chhattisgarh, I stay in Varanasi. There has been no marital relationship. I have not seen my son. She runs a successful business, several businesses in Chhattisgarh. There is no inclination also on her part to come back. She's not even attempted or come back even for one day in the last 11 years. Your lordship, all I'm requesting is your lordship will, the maintenance order, whatever it is there, your lordship will decide one amount and I will pay that, but your lordship will at least grant me a decree of divorce. It's the most humble submission.
Milord, I have something to submit. On the first day, that was almost 4 months back, the SLP was to be dismissed because she failed to pay even a single pie to me for the last 3 years. He's a man of having 900 crores. It's not denied.
Of course,
just a minute. There is no denial.
There is no document.
1 minute.
I didn't even interrupt you. Therefore, there was a refusal to issue notice. Asked him to file an affidavit to establish his bona fide. So out of 28 lakh, today he pays only 4 to 5 lakh rupees. A small affidavit is filed where there is no denial of the fact that one, his brother is no more, he is the only son. One is studying in London, the other is studying in Mumbai. I am having a son who is not even paid a single pie. When I asked in the High Court stage, my lord, to make the payment, there was a mediation indeed in Raipur. He made an allegation that the son is not mine, it is his father's son. And today even the allegation is made against me. And today he is saying he has not allowed me to meet my son.
Very
a father, just a minute, please don't make these kind of interactions. Look at the conduct. He, my lord, when my lords were kind enough to ask him explicitly on the first day as to what happens with regard to the compliance of the entire maintenance, the answer was, give me time, I'll deposit the entire money. And today, affidavit is filed where he says, I'm having 25,000 rupees at the same time, my lord, income.
My friend doesn't disclose that I
This item 40 is dismissed.
Because may I just point out, because your lordship.
You are not going to reappreciate evidence here.
No reappreciation. Because for 11 years we've been staying apart.
Okay.
There is no.
All that High Court has examined? Yes.
No,
Now what is your case?
Yes, but in this, he has filed a counter only yesterday. Give me 1 week time to file a rejoinder.
What rejoinder? What has he stated in the counter?
But the counter is cryptic. He doesn't deny that he doesn't have 900 crores. He doesn't deny that his son and daughter are not studying in London. He doesn't deny that he doesn't have 34 cars.
You want enhancement of...
Enhancement was 50,000.
How much has it
But
been?
I'm already, I want to be fair with my lord. But I'm only having a business which is run by...
Good enough. 50,000 is good enough.
But I'm having a son also with me.
It's okay.
But I'm having a son with me. So to enhance it at least.
This is also dismissed.
My lord wanted to examine this issue. I have given file. There is no reply into that.
This is all factual inquiry. We won't do it. Yes.
There is nothing called factual. All that
50,000 is reasonable if you are having your own business.
No, I don't. But the business is a charity. It belongs to a trust. I don't have a single income except 20,000 rupees. And I will only request my lords to consider. Look at his status today.
You don't pay income tax?
I pay.
No.
I pay more.
How much have you shown as your income?
7,20,000.
Well, at 7 lakh, I have taken 5 crore to establish that coaching center where students are studying and I'm getting money.
She is paying an EMI of 5,71,000 per month.
Why should I be interested?
I am my monthly.
No, yes, okay. Next matter.
Well, would your lordship only consider? Because I will.
We won't consider anything further. Both the petitions are dismissed.
One last submission, brother. If your lordship is so kind, brother, just one last submission.
Nothing. Yes.
Brother, I'll take 5 seconds, brother. If your lordship is so kind.
Sorry. Yes. 41 letter.
Great.
Lordship, I'm appearing in item 42 on behalf of the petitioner. I have to be candid that a similar matter arising out of the same parties, between the parties, a judgment has been passed against me. Though I have challenged the judgment, I have filed a review petition. The review petition was listed yesterday before Chief's Court, and the matter is still pending. Review petition is yet to be decided. So I'm only requesting that this matter be deferred for another 2 weeks. After Diwali vacation, the matter may be listed.
On the prayer of the petitioner, the present hearing of the present proceeding is adjourned by 2 weeks.
I'm deeply obliged.
Your Lordship may give us a date, Your Lordship, because it's otherwise squarely covered by the judgment. They've just reiterated.
Review petition is pending, my lord.
My election petition, Your Lordship, which has been held back.
Take it after 4 weeks. We'll give a date.
Yes, sir.
I'm deeply obliged, my lord.
43, there's a letter. Letter.
45.
Letter.
46.
Also letter.
47.
Yes.
47.
That's 47. Please, Your Lordship. My lord, last time your lordships wanted me to, we have filed that additional affidavit, including our reply, but it's my duty to bring something to your lordship's notice. I'm before my lord saying it is an innate lack of jurisdiction, because when you yourself have made the predicated offense 400, you cannot do more. That is my case. That you have specified it's only 436 crores, then proceeds of crime can't be more than 436 crores. You've already attached 436 crores, you can't attach more. It's a lack of jurisdiction. This was my case. Your lordship said last time, anyway, they issued you notice, alternative remedy, and I said this is not a case for alternative remedy, it was my entreaty.
You didn't reply to the show cause notice.
No, I have replied. It's my duty to bring to your notice that so far as one show cause notice is concerned, they have passed another. So, between the last hearing and today. So far as the other show cause notice is concerned, they've reserved orders. Now, my grievance is this, they have not touched on jurisdiction. So I am making a submission which your lordships will consider, and I feel it's a fair suggestion I am making. Although, my lords, I would urge still, if it's lack of jurisdiction, that why should the authority decide? Your lordships will decide. I will file my appeal. No, I will, exactly. I'm making a request which I feel is reasonable. I will file that appeal, but please let jurisdiction be decided as a preliminary issue, otherwise I'm tied up forever. Let jurisdiction be tried as a, because if I let it just be tried by the tribunal as a, and I go to the.
Take the jurisdiction point before the tribunal.
Yes, but I'm seeking that it be taken as a preliminary issue because otherwise I get caught up in a long hearing on the facts of the matter. I'm only seeking this relief alone, nothing else.
You may withdraw this with a view to file appeal and keeping all contentions open.
My lord, that does not help me, my lords, because why I'm saying so is where if without jurisdiction.
No, because
if I succeed on jurisdiction, matters over.
But problem is if you fail in jurisdiction, again this appeal comes back in another.
No. No, my lords, if I fail in jurisdiction, then they go forward to hear the rest.
Issuing so-called notice for wrong reason would not be construed as having no jurisdiction.
My lord, can I answer, my lord, there? I'll explain why. It's on the strength of your lordship's court's decision. Your lordships have said that unless there are proceeds of crime, there is no jurisdiction for the PMLA Act. This is your lordship's decision. That proceeds of crime is a triggering point, is a jurisdictional fact under Section 3. They have quantified proceedings of crime as 436 lakh crores, in which case they have no jurisdiction to proceed against anything more than that. Is a pure question of law. I'm saying so, my lords. I'm saying so. I have unfortunately, the original authority did not even consider this argument, did not deal with it. I will take it before the appellate authority, but my request is, please let that be decided. It's a short point, let him decide it's a preliminary issue. He decides against me, then I face the rest of it. But if he decides because it's a preliminary issue, is a very simple issue. Jurisdictional fact, what are the proceeds of crime in this matter? They themselves, my lords, I'm just reading it out to your lordships. My lords, may I read it out to your lordships? They say
the jurisdiction point open.
the derived proceeds of crime to the tune of 464 crores. They've said so and they're predicated of
They are dealing with these issues day in and day out. So they will consider, why not?
No, my lords, I'm saying, my lords, I'm saying I will not press this SLP at all before your lordships, but please give me the opportunity of having it as a preliminary issue. That's all I'm requesting. Because I have a good case on jurisdiction on the face of it and on the strength of the judgment in that Madhullah Chowdhury's case. I have a clear case.
These are not regular court proceedings. Appellate authority will take into consideration your issue of jurisdiction also.
My lords, against 464 crores proceeds of crime, they have attached 893 crores. I now, more than this, I don't.
Shall we pass the order or you will?
My lords, I'll withdraw it with liberty to, but I make this, my lords, would your lordship say, and that I will request the authority to consider jurisdiction as a.
Let them decide on their own, yes.
Yes, you please put as my submission. As my submission.
Also appearing for the petitioners, submit that in relation to the subject proceedings.
Since an order has been passed.
An order has been passed in relation, in connection with the show cause notice dated.
Malaj, I'll give the dates to your courtmaster. I'll give them to your courtmaster. Just give it to
notice dated.
Malaj, I'll give it to your courtmaster. Let them know.
Whereas in respect of the other show cause notice dated blank, hearing has concluded before the adjudicating authority.
Authority and orders reserved.
And orders have been reserved. In such circumstances, it was submitted before us that the petitioners would not like to proceed with the present SLP, but approach the appellate forum under the, that is the PMLA Act.
Yes, section, appeal is section.
Appellate forum under the Prevention of Money Laundering Act, whatever the year. Prevention of Money Laundering Act. Mr. Sundaram wants us to direct the appellate authority to take this question, take the question of jurisdiction as the preliminary question. Stop. We are, however, leaving it open for the appellate authority.
My lords will say we leave it open for us to approach the authority.
Leave it open for the appellate authority to decide on that aspect.
Lordship. My lord. My lords, the numbers we have given, 10th and 22nd June. We've given the dates. We have given the dates, my lords, of the show cause notice.
Is dismissed as withdrawn.
Disposed of, my lords. Accordingly disposed of. There's a big difference in the way it's said in the other quorum.
Is disposed of accordingly.
Lordship.
What date?
No date.
Because I've handed it over to the lawyer.
Yes.
48, I just opened with volume 2.
Preemptory.
Sorry.
Preemptive.
Preemptive.
Yes, so the High Court seems to feel that this is some sort of an advanced ruling, which is not correct. But just by way of background, your Lordship will recall that I first approached this Honorable Court, and this court's order is at page 621 of volume 2. 621 volume 2 was the 31st July 2023 order, where we came by way of an Article 32 petition. And the petition was...
you won as an independent candidate. Now,
yes, I succeeded. Now I want to float...
Political party.
Yes, I want to float a particular political party.
Whether you would enter disqualification...
Under 2, that's the issue. Now it's... Absolutely right. So you may just have a look at that since you're...
What's the consequences?
Yeah. Now two issues arise.
Petition would be maintained.
Pending in our court. It's pending before a constitution bench of our court. And I'll just hand over that compilation which we have. So just because it's a 145.3, so it's really pending before a 5-judge bench. So I'll just hand over that compilation. This is in a case titled Amar Singh versus Union of India.
If it is pending, let it be decided.
No, I need relief in my case because I have, please see let me just.
The issue is pending.
Yes, on this particular clause. So I'll just come to that. So let me just give me a little time. Your Lordships have a very good grasp of the matter. But let me just indicate the point which I'm making. As you correctly put to me, I was elected on an independent. Now the question is as to whether the disqualification para, which I'll point out, under the 10th schedule applies to a situation like mine. Exactly. So it does appear to apply to independent who joins a political party.
Which is existing. You want to form fresh.
Form afresh. Because the expression join, as we understand it, we have also checked up and we have actually filed all the previous, my lords, the history behind this particular purpose. The idea does not appear to have been to stifle the creation of a new political party because it's expressly record. I'm sorry.
You may form and then see what consequences.
No, but what has happened, you're right. So that could have been one thing if there was.
Action has not arisen so far.
No, so there are two elements to that. So I'll answer that.
Proceeding on some hypothetical issue.
All right, correct. So I must answer both those points. So the first point, the first answer to that is that it is not entirely hypothetical because the speaker sought the opinion, which I have placed on record, of the Advocate General. The Advocate General, because there's uncertainty on this too, however, gave an opinion. So therefore, the speaker is going to be guided by that opinion. I've placed it on record. I'll point it out to you. So therefore, it is, I know what the fate is. I know what the fate is going to be if we go, because the speaker has indicated his mind. He, very fairly said that, look, I have consulted the Advocate General and this is the position. So I can take you to that. So this is one aspect. But your Lordship has raised a very pertinent second point, which is to say that is this theoretical? Now, what we will place before you is the Constitution Bench judgments which say that where there is a serious apprehension of a fundamental right being breached, it's not necessary for a party to wait for the violation and thereafter come to the court. You can, on that serious apprehension, because it is a fundamental right, approach the court in advance. So therefore, the whole principle seems to be lost. So therefore, my writ, I'll take you to my writ.
Which judgment is this?
Yes, I'll just take your Lordships to it. Which is the one? No, go to
page 40 of the compilation.
Yes, just have a look at the compilation, please. I've just given it. No, can you use the declaration, please? Right? No, the other one.
Is page 40 DAV first?
Yeah, DAV. Yes. So let me give me the panel. So sorry. So may I just answer this point? So please see, take the judgment at page 269 Sorry, page 40, my mistake. It's page 40 of this compilation.
DAV College.
Yes. And please go directly. No, Lordship, just give me a moment. Just give me 1 second. Give me the para. Para 44 at page 57. We have already found that none of the provisions of the Act offend any fundamental right of the petitioners. But it is contended on behalf of the petitioners that in a petition under Article 32, once it is alleged and a prima facie case is made out that the fundamental rights of a citizen are threatened or violated, this court is not only bound to entertain it for determining the extent to which the allegation is valid, but is also bound to go into the question, if raised, that the law under which it is alleged that his fundamental right is infringed is invalid on the ground of want of legislative competence. There are two facets to this submission. Firstly, whether ultimately any fundamental right in fact is threatened or violated, so long as a prima facie case of such a threat or violation is made out, a petition under Article 32 must be entertained. Secondly, once it is entertained, irrespective of whether it is found ultimately that in fact no fundamental right of the petitioners are invaded, the vires of the legislation or the competence of the legislature to enact the impugned legislation must be gone into and determined. While the first proposition is valid, the second is not. So the first proposition is valid, which means threatened in terms of threatened to be violated. So even if it is threatened to be violated, because you don't have to wait for the cause of action to be complete insofar as the fundamental right is concerned. Now, this was recently followed, your lordships will see, at page 103 of the same compilation.
It's your fundamental right to form a party.
19(1)(c). Yes, so 19(1)(c).
Party.
Yes, so we have gone on a triple that 14, 19(1)(c), and as far as, so please take up 19(1)(c). Straight away. 19(1)(c), association.
The one.
Yes.
See, our exercise also would be anticipatory in nature, because as a constitution bench is addressing this question.
No. So I'll just tell you, Lord. So let's just go 2 or 3 steps, Lord. So first is I require interlocutory relief. Just a minute. I'll just go step by step. I need interim relief. I'm not here to raise.
Not disqualified.
You want a vaccination.
I want a vaccination. Now, whether I'm entitled to a vaccination or not is the second issue. Now, first I'll answer the question. 19(1)(c) is a citizen's fundamental right to form an association or union or cooperative societies. This includes an association would, in our respectful submission, include a political party, because this is the highest form, and it's also 19(1)(a), because it's a matter of it's a manner of speech and expression through the political process. So that's as far as 19 is concerned. I'm sorry.
It would be matter of interpretation of Schedule 10.
Absolutely right. I agree.
So it's
I agree.
that somebody is violating your fundamental right. There's no as such threat also.
No, there is a threat. So let's just take up my writ petition.
Look at generals.
Yes, absolutely.
Is neither here nor there. That's not binding to anybody.
No, the speaker gave it. No, it's not me. The speaker sought for it. Please just have a look. It's in the second volume.
Mr. Diwan?
Yes, yes.
We want to do a little bit of study ourselves on it.
Okay, well,
Keep it on next Tuesday.
Certainly. There's a problem on next Tuesday for me, because there's a constitution bench.
Okay.
So any date you consider appropriate.
Because
as soon as possible, but any date you consider appropriate.
Then after this, because next week.
All right, very well. Immediately the week there. So that, sorry, may I just suggest, just give me a moment. I'm not here in the UP.
List this matter on
Tuesday or
5th December.
Very well.
2023.
I might just indicate that we have given you skeletal written submissions also in the compilation at the beginning. That's really my case.
Point has to be, yes.
With case law. Grateful.
Which state is this? Bihar.
Bihar.
And how many independent candidates are there?
I am the person who.
Here is only me. No, but he wants to know. We'll find out. We'll check up and let you know. In the Legislative Assembly, how many? We'll find that out. I don't.
So if it's only one, then what is the consequence? Might not.
That may also be
might
right.
not be required to form a political party.
No, that's all right. In any case, we'll come back to it, the exact facts. Grateful.
Thank you.
Lordship, in item 49, requesting pass over, please.
Then it will go. Accommodation is asked for on behalf of the petitioner. List of 2 weeks, 3 weeks.
Grateful.
May it please your lordship. Unless in item 50,
also,
in the first matter, my lords, formally notice has not been issued because last time letter was there. In all other matters, notice has been issued. It's against the common judgment. Only in the first matter, my lords, Ghansham Bhai.
No, there's a letter for a.
Yes, my lords, I am requesting in all other 3 SLPs, your lordship was pleased to issue notice. This one, my lords, formally.
50 also.
My lords, they want to file counter, but formally your lordships have not issued notice. So notice we go.
I'll explain why I wanted the counter. Let notice be issued. Now, in the impugned order, the High Court relies upon a suicide note. That is not on record. I thought, let me bring it on record. Now I am instructed that it is not available with the private parties. In fact, it was in the police record. So my request is, in fact, that the state to whom notice is issued, let them file that on record for everybody to see. Because it is relied upon.
Ask for the adjournment. You have asked for.
Yes, correct, my lord. Now, I had asked for it. I am appearing for the complainant because I wanted that suicide note to come on the record. But now I am instructed that.
That was not before the court minutes. The High Court, it was not there.
Of course,
but I am not opposing.
Relied upon.
What I am saying is.
Okay, notice, issue notice.
And minutes I am requesting.
The first is for the state.
I'm appearing for the state.
Achha.
Yes.
Learned counsel appears for the state and accepts notice.
Yes.
Hence, formal service of notice on state is waived. Any other party?
No, not only 2 parties.
There was an order of no coercive step throughout the proceedings.
Complainant?
No, that I am for the complainant.
Oh.
I am for
And,
the complainant.
So there's no other party.
No, only 2 parties.
Yeah, accused, we are the petitioners.
There are 4
petitioners. My friend is appearing and the state is appearing.
No, just kindly see page 31, para 9.5.
Who shall we issue notice on?
The notice will be issued to the state and the
complainant.
We will accept.
They are appearing. They are appearing in the connected matter.
We will accept notice for the
Who
state.
is your advocate on record?
Please, madam.
Who is your advocate on record?
Ms. Pooja Dhar.
Ms. Pooja Dhar appearing for the respondent number 2 also accepts notice.
Please, madam. Now, madam, kindly see page 31, para 9.5.
No need of further.
I'll tell you lordship why. I was just
coercive steps will be taken. The police has issued me notice for appearance on 6th of November. That notice I have, these are the notices which have been issued to me.
No
for
other
appearance.
order. This is okay.
But I may not be arrested. I will appear. There is no problem.
See, you should have filed anticipated.
But this is arising out of a caution proceedings. But
should have filed anticipated. There's a difference.
But
there was coercive
438, my lord.
there are coercive actions.
Coercive action is too big.
Correct. Now, my lord, may I just indicate the point I was making?
Since your lordships are entertained, have issued notice in the matter minutes.
Yes, we are issuing, that's what we are
In
issuing.
the 482 proceeding, we are not issuing.
Yes, my lord, before your lordship closes the hearing, may I just indicate the point I was
We have
making?
not closed the hearing, we just
No, my
adjourned
lord,
it.
for today, my lord.
We were protected right from the beginning, Mills. Why should we arrest it in the meanwhile? Mills, I will cooperate with
How do we know that you will be arrested? You apply for anticipatory bail here.
Correct. Now, my lord, in para 9.5,
50.
Yeah.
The rest are adjourned for a
Yes.
period of 3 weeks.
my lord, in para, may I just give me 1 second. My lord, in para 9.5, the High Court relies upon the suicide note. That is critical to this case. It's not available with the.
We are not passing any other order.
No, I'm just only requesting that the state may be directed to place it on record.
That let whatever state wants to do.
Mills, I am requesting Mills once again, Mills. I was protected all through the High Court, Mills. When the matter
Okay,
was taken to the High Court.
No further.
The High Court is now dismissed,
No
but
more
it is
protection.
was 30 what?
Meaning thereby there is some evidence against you, so.
But that's why Mills, still your lordships have entertained it. Now during the pendency, I am requesting. That's all I'm saying.
Not necessary.
Let them not rise. I will join the
What
investigation.
is preventing you from filing an anticipatory? What
Yes.
is preventing you?
In one case, Mills, that has already been rejected in one case. Plus, I will be unnecessarily when your lordships are considering it. Since your lordships are in session of the matter,
You can't make it a 3-in-1. 482.
Mills, these are. I am High Court had protected me. So, Mills, when your lordships are entertained, Mills, your lordships are considering the matter, Mills. Meanwhile, why should I be arrested in the meantime?
In 482, we would not grant an order staying arrest. Yes, next matter.
Grateful, no.
Your lordship have fixed some date, Mills.
We've given date.
Item 51, there are 4 connected matters. Lordship, pleadings in 51 are complete. I beg to appear for
You
the
are
petition
for
in item 51. Yes, ma'am.
Hurtful thing?
Yes, Lordship. In item.
Time for the state, my lord.
In item 51.4, my lords, counter has been filed yesterday only. I seek time to file rejoinder. my lord.
Nobody has filed the original order of passing PIL.
Lords, I have filed in my 51.4, it is there. In item 51.4, it is there, my lords.
51.4.
4. Yes. It is at, my lords,
Deepak Yadav?
at page, my lords, 58 in 51.4.
51.4.
At page 58. I have filed, my lords, all the orders passed by the High Court in that PIL.
So it was pursuant to that order.
The FIR was registered.
Indeed, your lordship.
Yes. So it was triggered.
Yes, ma'am.
2015 order, and the High Court directed to launch a prosecution against all the guilty officials.
Lordship, the special judge order.
7, Mataji, Gandhi, etc. That can be given. What is the other matter? The Mataji lives there and other Shambhunath mixtures.
The synopsis, the counter, the maybe impugn order also. All are very poorly done.
Apologies, Leadership. In that case, my lords may permit us to also file a 2-page synopsis. We'll put our respective points.
Generally, nobody reads. My problem is, nobody reads before filing it. Maybe you people are too busy to read, but that doesn't mean that such a casual approach should be tolerated.
Apologies, Leadership.
Even who has filed the counter?
File the counter.
Standard paragraphs. The person who is an IPS officer is filing that I've been made to understand in my vernacular language the contents of this affidavit, this and that. Is this the way you file?
Count as 51.1, which matters?
51.
51. I'll look into it, my lord, that I have not drafted. In 51.2 I have filed.
And it is standard. When you are filing counter, the officer has to.
I apologize unreservedly.
His name first, his resignation, that he is authorized to file this.
I apologize unreservedly.
Further?
I'm not. I'll look into it, my lord. I'm not
So
marked on
most
that matter.
sincere apologies for the inconvenience. We'll file a 2-page synopsis also, which will have the concise case that we have.
It takes time to.
I completely bow down, Lordship. I completely bow down.
Synopsis does not serve the purpose.
And I completely bow down, my lords, and I'm extremely apologetic for this.
If I may state, my lords, in item 51.4, you can, my lords can check the synopsis.
Normally we did the first.
My lords can check 51.4.
I didn't find that. I asked my clerk to find out that order also, and he was able to.
After vacation.
My lords can have a look at the synopsis.
Take it after vacation, you file your.
My lord.
My lords may direct to file rejoinder, permission to file the rejoinder also.
Let us understand the counter affidavit first.
Counter has come in my case.
Let us understand.
Okay.
Yes.
On a non-miscellaneous day, my lords?
List 1 week after that, November after vacation. Rejoinder to the petitions in which counter affidavit have been filed. Maybe a rejoinder to be filed in the petitions where counter affidavit is there. Yes.
Lords may consider fixing it on a non-miscellaneous day, my lords.
Non-miscellaneous day.
So great.
Obliged.
Obliged, Lordship.
Good.
To the this is coming after notice, Milan. The complainant was none other than the employee of the same office, and he got loan up with us for a sum of 650 rupees. And this man is in jail for some past 2.5 months, Milan. 74 years, man.
Concurrent finding.
In the meanwhile, bail may be given because he's in jail for the past 2.5 months, my lord, because 74 years with all ailments.
I'm not appearing.
74 years for.
But I'm appearing for the state. But there is some defense evidence, etc. But the bribe amount, Lordship will note is 600 rupees.
600 rupees.
Lordship.
It may be found. I mean,
I leave it to your Lordships. I'm just saying.
corruption is corruption.
Absolutely. There's no question about it.
It hardly matters.
But here your Lordship, I see the complainant is none other than the employee of the same department, junior assistant against senior assistant. Now, senior assistant arranged a loan of 3,000 rupees for the treatment of father. That is being treated as a gratification. And there was a clear violation of all the.
Appreciated. How much sentence has been imposed?
1 year. 1 year. 1 year.
1 year punishment. And 2.5 months is already in jail. Bail may be granted. 2.5 months is already in jail.
We are not interfering.
Look, your Lordship, just.
No,
your Lordship, kindly see the complainant is none other than the employee of the same department. And here, the question is.
All that 2 courts have already.
Appreciation of evidence.
No, here there was no. Honorable court time and again held my lord.
5 years, 5 rupees, 500 rupees, or 5,000 rupees.
No, I am not on the question of the amount, but there, section 20, subsection 3 provides for a different type of presumption, my lord. Where the amount is trivial, the presumption provided for under section 20 does not apply. I am being convinced your Lordship pleased to issue notice and counter is yet to be filed. He is a man of 74 years, my lord, with all ailments. Heart patient. He has already.
Okay, then you file counter. Okay.
In the meanwhile, he will be released on bail.
We should. No, we are not releasing.
Lordship said we should notice.
Notice issued. Counter affidavit be filed within 1 week.
Yes. Friday it may be had, my lord. He is.
Beyond that, there too.
He is a cardiac patient undergoing treatment.
That the jail authorities will take care. Yes.
Jail also is undergoing treatment, severe treatment, my lord. 74 years.
Medical record is there.
We have already filed the medical record before last year, my lord.
Page 1.
And
Yes.
2.5 months he is in jail already.
142.
Next one.
Unfortunately for him, my lord, by the time the exemption application came, there was a direction that he should be nabbed, and immediately he was nabbed. By the time the SLP came to be taken up, he was kept in jail. That's how it is continuing.
Two courts have found the against him.
Page 142, your last kindly see medical record. 142.
You may file
For the
medical bail application.
December
Yes.
first week. Yes, next matter.
Next Friday, it will be next Friday.
No, not next Friday. It should come after this Diwali vacation.
Medical bill application will file Friday.
See that too, whether you file it or not, that's
74 years, my lord. Sheer regard for the age of the person and the ailment, my lord. That's
fine. You file the medical bill application, we'll consider. Yes.
right. That will kindly be observed, my lord.
What observe? You have to file.
Everything needs to be observed.
My lender friend also may not have serious objection for the bail. Ultimately, bail 74 years, my lord. He is having all types of.
That you are sick and will consider as and when file.
So already we placed the record before last year, my lord. 55. We have said that this is the medical state of a person.
It has to be of such nature that you cannot be treated within the correction alone. Yes. Next matter.
That's okay.
In this matter, I am appearing in person, madam. We have filed Vakalatnama in this matter, but it is not on record matter. It is not reflecting in the cause list.
Yes.
We have filed Vakalatnama in this matter, madam. It is not reflecting in the cause list.
See, there are several petitions, I think, possibly before the.
Only one. Only.
This is a generic.
Yeah. Generic.
On generic also there are few petitions. Who is for the union?
For the
You check up. You tell us how many petitions are pending. We'll tag them or.
Your Lordship, one thing there, the state government has filed every. They have not supplied copies to us. We don't know what is the stand.
That you ask them, they'll supply.
Yeah, last time also we told.
For state of Haryana, long with supplied to them.
No, Haryana, we have got, not other states. Haryana we have.
So you ask, write a letter, then they'll supply. And you check up. Then some further development.
We want to file a rejoinder.
Further development has taken place. That National Medical Council issued a notification. Then we do. All these facts have to be brought.
Government is propagating generic drug.
Every state government is propagating only in the government hospitals.
Yes, Your Lordship.
In state of Haryana, we also issued notification for them.
Because National Medical Council give a prescription guideline.
In the name of generic drugs.
Generic drugs, Your Lordship.
But ultimately it don't serve any purpose. Because when you go to the pharmacy, the pharmacist will ask you, I have of this company and this company. Which one do you take?
There are generic drugs.
Then he will actually ask for the company which is internationally known.
There are special stores for
Generally.
Hospital.
They have opened several generic Janaushadhi Kendra.
In our case, in CGHS, we always get generic.
Your Lordship, Union has filed Your Lordship, Union has filed their affidavit. We have to file a response to that, Your Lordship.
But you also find out what has happened. Yes. Lot of water has flown after this. We find out.
That will do.
Bring it on record.
That will do, Your Lordship.
January में रखिए list. January as petitioner wants to
file rejoinder.
File an additional affidavit bringing on the record the present position.
Yes, Your Lordship.
On the question of prescription, on the question of what use use of generic names for pharmaceutical products, drugs and pharmaceuticals.
Yes, Your Lordship. Under the deep level.
Okay, go.
Please, madam.
My lord, pleadings are complete in this matter. This case involves removal of 2 doctors from the Institute of Medical Sciences in a PIL by the Honorable.
Years back, your
They had served 10 years
decision
back.
of 2014.
My lord, they had been serving for 9 years at that time, my lord. And because they accepted,
Pursuant to the order passed by the High Court in PIL,
my lord, I'm so sorry, my lord.
your services have been terminated pursuant to the orders passed by the High Court in PIL.
That's right, my lord. That is one of my grounds, and I wanted to show your lordships what the PIL petitioner had said in the.
What do you do now?
My lord, I'm without a job, my lord, because when I joined this institute, I was a
without job.
Yeah, yes, my lord. I was a doctor in the government health department. I gave up that job to join this medical school, my lord, in the Institute of Medical Sciences. And 9 years after service, I have been removed in a PIL. So I am neither in the government service in the government health department.
No, but thereafter you also were implemented. I mean, you went to the Supreme Court. Supreme Court asked you to go to the High Court.
And my lord, the review.
Application for implement, you were heard.
My lord, even the
order was reviewed, again dismissed.
My lord, even
now they are challenging the original order of 2014.
My lord, even the Institute of Medical Sciences that had employed me filed a review, and their review also, in the review they said there are good grounds for making a relaxation because candidates in this faculty are not available, and there are central government orders, my lord.
Okay, one minute. What is your stand?
Let's after the institute had filed the review petition. After the institute had filed the review petition, after the dismissal of that review petition, my lords, these 2 doctors were terminated because contempt was also on the head of their millers. So they were to be removed after that.
Who is the PIL petition?
My lord may see his affidavit at page 186.
Who is here?
He is not here, my lord. One PIL.
My
lord, we made him a party, my lord. The report of service has come that no such person is traceable. And one petitioner, my lord, the PIL petitioner filed an affidavit saying that he never filed this petition, my lord. And the impugned order does not deal with the affidavit. The PIL petitioner's affidavit is, I never filed this petition. And yet the impugned order does not deal with it, my lord. At page 186, if your lordship would please see.
Then who had filed that? PIL.
My lord, they are not here. One PIL petitioner filed an affidavit that I have never filed it. The impugned order does not deal with the affidavit. The other PIL petitioners never appeared, my lord. They have not even appeared here, never appeared in the review also, my lord. So, my lord, in a very suspiciously filed PIL, my lord.
What is your stand now?
Now, Malas, they are no more in the service. That is my stand, Malas. What else?
My lord, your lordship.
What is your stand?
No, you want them in service or you don't want them?
Malas, the posts are not there, so how to wipe?
Yes.
Posts are not there. Malas, the posts are not there.
Posts are not there.
My lord,
Vacancy is not there.
Vacancy.
I'm not sure.
So if vacancy arises, would you like to?
My lord, there are no candidates available. I don't believe that is correct. I don't believe that.
Will you take instructions?
I'll take instructions.
You take instruction on 2 grounds.
Yes, ma'am.
Who are the petitioners who file the PIL?
Yes, ma'am.
And whether
vacancies
are available or not. When the matter is called on for hearing from a Senate Council for the petitioners submitted before us that the applicants in the public interest litigation, out of which the present proceeding arises, are not traceable. So, notice was served. What is the notice status?
What is the report?
The report is that they are not traceable.
My lord, that is what the report is, my lord. I'll just point out, my lord. The office report says that just show them.
Order sources. The last one from this month.
Which order?
3 to 12. What
The order of 24th August, my lord. 2020 says.
Service is complete on respondent, but none has entered appearance. Respondent after 5 years.
Yeah.
Which respondents are the PIL?
Well, I'll just point out. If your lordship would bear with me for a second, my lord. Yeah. 4th 8/2020, my lord.
Tell us from your course title who are the makers of PIL.
My lord, they are
13, 12, and 11.
11
13.
respondents, 11, 12, and 13, my lord. My lord, 13 I deleted. In this order shows, my lord, 13 I deleted because we could not serve him, my lord.
These reports say that there is no such person.
Well, my lord, I'm instructed that there was a police report that said that he is not traceable, my lord.
In fact, it was 4 years to serve them.
Are not traceable. Stop. All the three are not
It's
traceable.
4 years it took us to serve them. It's 4 years.
11, 12, 13. The state shall file a report as regards whereabouts of the petitioners who had brought the PIL stuff. The state shall also apprise this court about the position of vacancy in the state medical service.
It's the Sher Kashmir Institute of Medical Science.
Now it is
SKIMS.
Vacancy
SKIMS.
in Sher Kashmir Medical
Institute of Medical Science.
Institute of Medical Science, Srinagar.
Yes, sir.
List after 4 weeks.
My lord, one submission, my lord. My lord, I said 2 are not traceable, my lord. 1 has filed an affidavit that he never filed that
Out of the 3
yes,
applicants, 2 are not traceable,
and 1 has filed an affidavit that he never.
and 1 applicant has, 1 PIL applicant has filed an affidavit
Before the High Court, before
that he did not
file this.
file the
Yeah.
said petition.
Indicate respondent number. Otherwise, my lord, it might become a. It's respondent number 12 and 13, I believe.
11, 12, 13.
No, no, 11.
We are asking you to find out this 11, 12, 13. They are whereabouts.
Yes, yes. All 3. he
All
can find out.
11, 12,
All
13.
3. My lord, may take it up on a non-miscellaneous day. This will.
Let's see, what was the allegation actually?
Plus, the allegation was that they were.
I'll explain, my lord. The allegation was, my lord, that in addition to a diploma in medicine, I had to undergo in addition to MD in medicine, I had to undergo a diploma in public physical medicine and rehabilitation, my lord. The All India Institute of Medical Sciences, Vellore Medical College, all of them said that there are only very few
And you will examine that.
only diploma required, my lord. Only.
Because we find the shortcoming in eligibility, then we only give an
My lord, I will show from the record that. My lord, may kindly take it up on a non-miscellaneous day. It will take 10, 15, 20, 30.
miscellaneous day in
Great. Much grateful.
December.
I'm much grateful.
But 55, I beg to appear on behalf of the petitioner, my lord. Lord, the short question involved in this case, my lord, is that whether contempt is made out in this case, my lord. Because now they have filed the fresh, my lord.
Appeal against contempt has been dismissed.
They have filed fresh contempt, my lord. This is IA number 212631. Lord, I have filed this IA.
So far this petition is concerned.
Yes, Lord. No contempt is made out, my lord, because, my lord, I have complied with that order, my lord. If my lord sees, my lord, they were page 26 is their initial appointment as junior engineer for 6 months, my lord. That was completely temporary, can be terminated without any show cause, my lord. Now this, my lord, temporary appointment kept, my lord, going on.
What has the Jharkhand High Court held?
My lord, Jharkhand High Court, my lord, REET petition, my lord.
No, in the contempt action?
No, my lord, in REET petition, they said that you decide my representation. I decided their representation, my lord, by reasoned order, which is at page 61, my lord. 61 is the reasoned order. Thereafter, my lord, they filed a contempt, my lord. And in contempt, my lord, no adverse order has been passed against me, my lord. But he has said to be, my lord, regularized with effect from 1990, my lord. Now, the law is very clear, my lord, as far as Nand Kumar Manji and other cases are concerned, my lord, he can't be regularized from the date, my lord, when he was temporarily appointed, my lord. We considered him to be regularized, my lord, with effect from 2011, my lord. His appointment was completely temporary. So, in my humble view, my lord, no contempt is made out because, my lord, we have complied with the order. Now, after disposal of this complaint, my lord, he filed a first complaint which is pending before, my lord, High Court. So, therefore, my lord, I had to move before this honorable court, my lord, by way of SLP, my lord. So kindly see, my lord, page 26.
No, he has filed a fresh contempt.
Yes, my lord.
So is that contempt pending or over or what?
Yes, my lord, pending because of your lordships have.
So that is pending. So we are not touching that contempt.
My lord, because of your lordship's order in SLP, my lord,
Yeah.
page 43, my lord.
It has
if
been
my
a
lord
John
see-
sanitized.
IN number 212631, my lord. Page 43, my lord.
Page
In fact, the
43.
second
Yes, my lord.
contempt was filed.
Just
my
one
lord,
second.
because they
Page
did not
43 of the
implement it.
IM, my lord.
Thereafter, they came after
Just
my lord,
one
with
second.
400 days delay, 40
My lord.
days in filing SLP, my lord. Did not do anything. Thereafter, in 2018, I filed. 2019, my lord, they came here after 476-day delays. And there is no order against him, my lord. The order is against the state government. State government has not come here.
Who are you?
My lord, I have been made party in the contempt, my lord. My lord.
But where is the order against him?
Yes.
We'll record that he has no allegation against you.
Yes, there is no problem, my lord.
Submission. So we'll dismiss the contempt.
There is no
That's
problem.
correct, my lord.
Yes.
Yes, my lord.
In court, the petitioner has come up in appeal against an order passed by the Jharkhand High Court in contempt jurisdiction on, what is the date?
25/8/2017, my lord.
Where do we get? 25th August 2017.
Yes, my lord.
In the contempt petition, the operative in the said order, it has been recorded, colon dash, para 910. That is the operative part.
Yes, my lord.
Huh?
11 also.
Para 9, 10, 11. Ten, 11. Land Council appearing for the respondents, who had brought the contempt action, submits that his client has not made any allegation against the petitioner.
Personally.
Any allegation against the petitioner, and hence there was no reason as to why she should have approached this court against the impugned order. Stop.
When the state has not.
In the contempt petition, however, she has been arraigned as respondent number 5.
Yes, my lord.
As the petitioner does not want to proceed, no, as the respondents, in bracket, what's
I am respondent number 1, lord. Other is the state authorities.
Since the respondent number 1, in bracket, the contemnee, himself submits through his lawyer, learned advocate, that there is no allegation against the present petitioner for committing any violation of the order of the court.
The state government has not challenged, rather implemented it. Sorry.
Order of the court. We do not find any reason to continue with the present petition. The present petition shall stand disposed of accordingly.
I'm so obliged, my lord.
Only one submission, my lord. They have implemented this order, my lord, where the other person. Nothing survives, my lord, in that matter that way, my lord.
Nothing survives, nothing survives. Delay condone. How many days delay?
476. And refiling 126.
Respondent number 1 instead of
Everywhere respondent number 1.
Rest are, my lord, with the state authorities, including the state of Jharkhand.
Yes.
56.
My lords, I appear for the petitioner at item 56. I'm being led by Mr. Balbir Singh, learned ASG. He's on his legs in another court. If this matter could be taken up on a non-miscellaneous day, I'd be very grateful.
Accommodation is asked for on behalf of the petitioner. List on 17th December. 17th December 2020.
That may be the last working week, my lords, before the
Yes.
vacation. So it may not, it will again be a miscellaneous day most likely. This is after notice, it can come on an NMD, subject to my lord's convenience. That week, the whole week should be miscellaneous, most likely. Any day, but just
Tuesday itself is a miscellaneous day, irrespective of week.
Very
yes,
well,
it's matter.
Very well.
57.
May I please, ma'am? Yeah, I believe the response is not there.
Yes.
The reply has not been filed. In any case, my lord has page 3 of the impugned judgment.
Who is for the other side?
Who is for the other side? The service done.
Services, they have entered appearance, my lord.
Some other matter is pending?
If my lord has page 3, the relied upon High Court order was itself challenged, and that SLP is pending. So it may be tagged along with those SLPs.
Meenakshi Arora had appeared. We'll just adjourn it for the none appears for the respondents. Hearing of the matter is adjourned for the day.
Yes, sir.
7.
$57. Oh, that is 57, no? 58.
58.
58, I am appearing for the respondent.
Lords, I'm led by Mr. Kamath. And
Again and again, my lord, they have been seeking adjournments 3 times. 3 times they have sought adjournments in the matter.
They were the one to mention it.
They had mentioned it. Actually, they have come up against an order by which the High Court has said that because the committee has been dissolved, the society has been dissolved, because it's
You are for the petition?
no respondent.
He's
And
for the
because
respondent. We are
he is
for the petitioners. We have been led by Mr. Kamath.
Mr. Bhushan will take it up on Monday.
Actually, again and again they are seeking.
We are very sorry, Malaj.
adjournments.
What to do?
Very sorry, Malaj.
Totally
Normally we are accommodating.
He's saying frivolous. We are that. And my lord
The term of the committee was over. He is seeking to.
No further time.
No further time.
On Monday.
No other time.
Very well.
Accommodation is asked for on behalf of the petitioner. List on Monday.
Obliged. Obliged.
59.
Please, Your Lordship, in item 59, Your Lordship, I have linked an application for interim custody because, Your Lordship, the child.
Where are you at present?
I'm in Delhi, Your Lordship, and there are
some research scholar and studying abroad.
No, I'm not studying abroad. I'm very much in Delhi. I have not gone after the incident, Your Lordship. And Your Lordship,
the child is not ready to go to you.
Your Lordship, that is what the child. I met the child in September. The child had told the mother that I have been asked because, Your Lordship, the circumstances in which the child was. And also stay because in the impugned judgment, Your Lordship, all I'm saying that at least you can spend a day or 2 with me. That's all I'm saying. And Your Lordship, this is just an interim application. My main petition is pending before this honorable court. I was granted custody by the custody court, by the. And Your Lordship, see this?
What are your visitation rights given by the High
Yes,
Court?
Your Lordship, may kindly see page 5.
Permitted to stay interact with the
Yes.
respondent on weekends.
Yes.
If possible, otherwise fortnightly, the child would be left.
Yes, Your Lordship.
A day or so with the mother.
Yes.
the child will also have the right to go on vacations with the respondent if he so desires.
Yes.
Well, as I'll tell my lords what happened, the High
So the child wants to come and stay with me. Now the child was actually taken away forcibly under the threat of a gun from his grandmother. And that is the main case, Your Lordship. I have got custody from the guardian's court. The High Court on the first day itself says that no, I'm not entitled to custody without going into the evidence. Today, all I'm saying is that there are ensuing vacations. Let the child come and stay at least for a day or two with me. Look at the mother. I mean, the child also needs the care and attention of the mother. And the child is not allowed to interact with the mother at all.
My lords, I just have one thing to say. My lords, may kindly have page 5 of the impugned order. The High Court judges had a prolonged interaction with the child alone.
Yes, we have read and we have
That's
already
right.
conveyed.
Now, what I'm suggesting is that she has met the child twice over. What happens is that because she left for Spain when the child was only 3 years old, he has had no interaction with her. So if my lords,
if child wants to,
yes. So my lords may take it from me that not from a whatever our differences might be, the child.
Accept the shared parenting.
That's right. So therefore, my lords may kindly just have my counter. I had made a suggestion. What happens is when the child goes alone with her, he also has abandonment issues. He thinks that the father is abandoning him. So I had suggested to her, it is my email to her, that you meet the child whenever it is convenient for him. I have in fact arranged for the child to meet. But do it
right.
Just
you don't have to.
That's right. But it's only for the welfare of the child because it unsettles the child. So I said, you start meeting the child. I'll keep away. Let me be around. I will not be a part of your conversations, so that we can just ease the child into being familiar with her. Because if the child, in fact, even today refuses to go with her.
That is
you may use your good offices and do something.
We'll take this matter after 2 weeks. In the meantime, both of you kindly work out an arrangement.
Yes, and Your Lordship may kindly see. After I met the child, just to give an idea of how the father is behaving, I met the child in September, Your Lordship. The father said the meeting went off very well. Now, before this honorable court, he says the child was very traumatized.
What we are requesting, both of you, learned counsel.
I hope she cooperates because the father.
She will cooperate.
Of a gun, the child was taken away from me.
Come back after 2 weeks. Come back with a solution.
May I also suggest one thing? My lords may also interact with the child or appoint a child counselor.
No point.
Because I leave it to my lords, but because the High Court
We are not a child counselor. I mean, we do.
Or my lords may appoint a third party and amicus in the matter that can interact with the,
not
the
amicus,
child.
but lords,
just
not
one
with
second.
that matter.
I may just be permitted. Because the child refuses
First,
to go.
2 of you try.
We'll do that.
You come back after 2 weeks.
Your Lordship may give us a definite date, Your Lordship. I'm requesting.
3 weeks for the Friday of the year.
I'm very close.
Item 16.
Wait, please.
Wait.
It is amply clear that the offence of money laundering is an independent offence regarding the process or activity connected to the.
I'm sorry, I apologize for that.
I think Mr. Raju is on VC. That's why.
Is that in some other matter? I
Yes,
guess.
that's right.
Item 60, item 60, Mr. Sibal was there. Unfortunately, he's unwell today, so he's not doing long matters. I'm here, Millards, to assist.
Yes, you are.
Please.
You were there.
That's right.
All the time.
Well, mine is 60.1. That's a different matter altogether.
60.1.
Yes.
So look, this is a bail application of a lady who's about 336 days in custody as on date. The offence is of money laundering, which is what she has been arrested for. And with reference to that offence, the first and seminal threshold question which your lordships will look at is what is the standard of law that has to be applied for deciding a bail application. The lordships are aware there is a special provision in terms of section 45 of the PMLA, which places a higher threshold for granting bail for cases of PMLA. But there is a proviso to that. The lordships just have the section for a moment.
PMLA actually.
Sikh and lady.
Second, I most person who is a lady, or there's an issue of a sick and infirm. But this is not exhaustive under any circumstances. And I am also not to be misunderstood to say that if I fall in the proviso, then I must be granted bail as a matter of right. But that's not the law. That's not the submission. But the submission definitely is that when your lordships look at a bail application, the rigors of 45 will not stand in the way for your lordship's consideration of that application. That application then has to be considered like any other bail application under any other.
437 also similar.
I am most obliged.
There's nothing new about it.
But that 437 applies only to the first year of the magistracy. Does not have any implication as far as the courts of sessions or the High Court or this honorable court, the powers that this honorable court exercises. So the first submission, your lordship's kind consideration is that we are to address this matter outside of the purview of section 45. Once I fall within the proviso, 45 is not what is going to detain your lordships. Your lordships will have to consider the matter, keeping the general rules of bail in mind as to the nature and gravity of the offence. And absolutely, that is one of the indicators or one of the the indicia which your lordships will assess. But that is by far not the only and not the predominant criteria to be considered by your lordships. In that context, please take note. What is the underlying case? What is the allegation against me? And the fact of how I was arrested and where are we today as in the case, so that your lordships can assess the necessity, because the test which has been laid down by this honorable court of a continued incarceration of a person is a single word test, and the test is necessity. Sanjay Chandra is the seminal judgment in that context. What is the necessity of keeping this lady in jail after 336 days of her custody, where the complaint against her stands filed? The material which they had, which they want to accuse her with, are in their possession. It has been placed before the trial court. The trial court will, in due course, consider those allegations and assess whether those allegations are sufficient or not. The offence by itself is an offence of 7 years maximum punishment and has a very different paradigm for determining issues of bail. Both, and that your ladyship again will assess from the 437 perspective. Keeping all this in mind, the test is only of necessity as to why a person should continue to be behind bars, either because of investigative need or because of the propensity and the conduct of an individual to tamper with evidence or otherwise obstruct the free flow of justice. It is my submission that neither of these two circumstances will arise in this case. And not only that, even if I have to assess merits to satisfy the judicial conscience of this court, the merits are such that a lot has to be said on our side as and when the time comes. This is not the forum, this is not the purpose of the present hearing, that I have to demonstrate my innocence, and I'm conscious of that position, and I'm putting that Lakshman Rekha for myself. The assessment of merits is not to determine today whether I am prima facie guilty or innocent of the charges that have been brought against me. The question of gravity of the offence is purely to be considered from the point of view of necessity. Is this a person, because of the grave offence, who is unlikely to face trial, who's going to flee from justice? If I am looking at a life in prison, if I am convicted, in that situation, somebody can say, yes, there is a propensity or there's a human desire of not reaching that point. But a person who is being threatened with a 7-year sentence.
No, see, the taste of subclause 2
Please, Bala.
is something different.
Your lordship are referring to 45.
45. 1 subclause 2. It's not
where the public prosecutor opposes the application.
Yes.
The court is satisfied that there are reasonable grounds for believing that he is not guilty of such an offence and that he is not likely to commit any offence while on bail.
This is like that 43D5.
I am most obliged. NDPS section 37.
Necessity question which may come in 437 That is not there in PMLA.
But I'm beholden. What I am relying upon.
He was saying proviso will introduce that element also.
No, please look at the proviso. Provided that a person who is under the age of 16 not applicable to me, or is a woman, or is sick and infirm, or is accused either on his own or along with other co-accused of money laundering of a sum of less than rupees 1 crore, may be released on bail if the special court so directs. It's a proviso to subclause 2. Subclause 2 raises a higher threshold. What the proviso does is it says that if you fall within these categories, you do not need to meet that higher threshold so long as you meet the normal positions of bail, because 45 starts with not.
Do not think it can be interpreted that way.
Well, let me take a step back. If 45 subclause 1 was not on the statute book,
yes,
437, 439 would be what would guide the jurisdiction of a bail court.
Does the proviso dilute subclause 2? That is the
Absolutely it does, and has been held by this honorable court.
Or does it negate subclause 2?
Absolutely.
As if it negates subclause 2.
It negates subclause 2. It does not guarantee bail, but it negates subclause 2. And I am supported by authority on that proposition, apart from the construction of the statute. So let me construe that provision first. Section 45, subclause 1, subpara 2, if it was not on the statute book, what would guide the court in granting bail would be the power under 439 CRPC. There is no other power. The existence of section 45 adds an element of a higher threshold. The proviso removes that higher threshold. It does not guarantee me bail, but it removes that higher threshold. So it says that for all persons who are accused under PMLA, 45 subclause 1 will apply. That the second part of subclause 1 will apply, unless you are covered in the proviso. If I am sick and infirm, for example, well, let's leave woman aside for a moment. If I am less than 16, if I am sick and infirm, then in that situation, for a constitutional court to say that no, you may be a sick and infirm person, you may be dying of cancer, you may be on your deathbed, but you still need to cross the threshold of 45 subclause 1, 2 to say that, oh, you are not guilty of the offense, and only then will I consider your bail application. In my humble submission, Mullahs, would undo the very purpose of that proviso. The proviso adds woman, like in 437, out of a constitutional obligation. There is Article 16(4), which talks about beneficial provisions or beneficial legislation made for ladies. That is a constitutional obligation of the parliament, which the parliament recognizes, and on that basis creates a distinction between a woman and a man. Today, brothers, neither party are challenging the inclusion of the word woman in the proviso. So we must implement it in the way that it is. The parliament is conscious that there are women of all kinds, all hues, all educational qualifications, all abilities as part of society. But like the parliament introduced a threshold of 1 crore for offences of money laundering and said if you are less than 1 crore, then 45 will not apply.
So here what is the quantum?
But there is no quantum, and that is precisely the point, that the mere fact
Raju. Mr. Raju?
Yes, Manoj.
What do you have to say?
On the interpretation as far as the proviso is concerned, My lords, may kindly have a look. The word that is used is may. It is not shall. Kindly have a look at 45.
No, whether that discretion. See.
But the first submission,
Even
let
if
me,
subclause 2, that discretion is available. If we
my
proceed.
lords are right, but let me formulate my submission, my lord.
Yes.
My submission is that
Yes.
that if the gravity of the offense is such, if the nature of the offense is such, if the nature of involvement in the offense of money laundering is such, even if it is a woman, the proviso, the subsection 2 cannot be given a go by. It would depend on case to case basis, and this is not surely the case where you can give a go by to the subset to the main section. The proviso says may, but if it is a very serious offense of money laundering by an officer who is holding a very high rank and in the chief minister's office, etc., involved in my lord, money laundering, I'll point out the facts of the case. The facts of the case are so gross that the benefit of the proviso cannot inure to this lady. That is my first. Therefore, it depends on facts of the case. You cannot say that in all cases where a woman is involved, the subsection 2 will not apply. That can't be a matter of right. That cannot be a matter of right. There are judgments to that effect. Also, the lordships have held that is not a matter of right. It is a discretion, and discretion will depend on the nature of the act and the nature of the crime. Therefore, the word may is used.
Okay,
so we'll have to
give us 2 pages notice. We can.
Very well.
So start considering the merits, because there are certain both legal and factual, which your lordships and my lordships will have to consider with the aid of submissions, especially given the fact that those issues were not considered, they were not raised or not available. The first, for example, is the compliance with section 19 of the prevention of money laundering. And what has happened there is that your lordships have rendered a judgment in Pankaj Bansal, which talks about after Vice Senthil Balaji, first second judgment then is Pankaj Bansal, where your lordships laid down compliance with section 19 is something which was matter, and the is entitled to release on bail.
So where is your pleading to that effect?
Which is why I'm saying, let me show the pleading. Please have page 295.
There's no, I'm sorry, there's no pleading in the SLP.
That's why I said.
So many things which are not there or which are there, but they're not there before.
But that's why I'm saying. So you're
there's so many things.
No.
You need to say something on that. So kindly give you your 2-page notes.
In fact, if I recall correctly, your lordships were of the view, because we started at the outset on the last occasion, said we apologize for that error that was committed.
No, we have not accepted so far.
So my submission then is this: if your lordships have not accepted our apology with reference to that one document, then in that event, it would be in the fitness of things. And I say this because I'll take instructions on in the fitness of things for me to remedy that error by withdrawing myself from this court.
No, that also will not permit.
We
want this to be brought to a logical conclusion.
About on this, so then your lordships will hear me on merits, because today
we are not permitting you to withdraw.
I'm saying,
after 4 times hearing.
Then I'm saying your lordships will hear me on merits. Then
yes, hearing you on
that's right.
And we'll decide on merits also.
No difficulty. So I'm here to assist for that purpose.
Yes.
And for that, as I said, I'd opened the matter with reference to the fact that there is a lady, and hence the proviso doesn't apply. Let me then proceed further. Please have what the underlying allegations are and what is the case. Because if your lordships have to look at the facts, then it is my duty, to point out those facts to your lordships. That's the first. These are 3 dates or 4 dates, which gave rise to the present matter. That's 15th of July 2020. A particular government order is issued by the Department of Geology and Mining in the state of Chhattisgarh, telling transporters of coal that they needed to take a manual no objection certificate from the department. Earlier it was on e-platform, and with effect from 15th of July 2020, it was made manual. The allegation is that this was done in order to facilitate or be the basis of. It's not on record before your lordships, which is why I'm saying, if your lord, because I have convenience compilations, etc. If your lordships have to look into the merits of the matter, those then have to be placed.
You had to produce whatever you wanted to rely upon.
But these are
part of the record of the
which is lordships. These are the. This is the. I have the complaint is there, and all of that is reflected in the complaint. I'll place it from.
We can read complaint.
That's right. So then may I do this? The complaint by itself is at page 102, annexure P9. So instead of going to the geo, let us begin with what the predicate offense was and how did the investigation begin. And that your lordships will find at page 106. Your lordships have it? There's a heading called predicate FIR. FIR 129 of 22, dated 12th of July 22, was registered by Kadugodi Police Station, Whitefield, Bengaluru, under sections, please mark here, 186, 204, 353, and 120B of the Indian Penal Code, against one Suryakant Tiwari and others on the basis of complaint filed by a Deputy Director of Income Tax Foreign Assets Division, stating that as part of a conspiracy, during the course of search by the IT department on 30th of June at room number so-and-so, Suryakant Tiwari obstructed the officials from carrying their official duties and destroyed crucial incriminating documents and digital evidences which supposedly contained important information about the illegal extortion, payments collected, and persons involved. Please just pause here. None of these particular provisions are contained in the schedule to the money laundering legislation.
120B, sir.
Actually,
because 120B as a standalone offense, whether it will.
184 is also there.
So this is 186.
Lord, Mr. Raju has.
120B is there. 120B is a scheduled offense.
Which is scheduled offense?
So my learned friend saying that 120B is a scheduled offense. It is a construction.
Or is that 384 is also a scheduled offense?
No, 120B in isolation a scheduled offense. How?
I'll point out, but I'll point out our contention is isolation. It is not only with isolation a scheduled offense, and I'll make my submission good.
For
Isolation was, and even if it is read with 384, still it will be an.
There must be conspiracy to do something.
Conspiracy which generates proceeds of crime. Conspiracy which generates proceeds of crime would be relevant. Simple conspiracy, my lords are right. If it generates proceeds of crime, then it would be a.
No, conspiracy to do what? What kind of conspiracy?
Conspiracy to do an illegal act which generates proceeds of crime. But that is not the only. 384 is added subsequently. My learned friend stopped there. 384 is a scheduled offense. So forget 120B for the time being. 384 is a scheduled offense. Extortion.
The is that the 384 is not where I paused was to indicate that the offences which were registered in the FIR were not charged. That's it, brother. I'll take a look. That's the Lordship just appreciate that I have
scheduled offense.
I have made my submission first on what as far as the FIR is concerned, because a lot has to be said in reference to 384 as well. Because today the difficulty they have to find a response.
This will take some time. We'll write for 10 minutes. Come back.
May I then request? There is no response by the state, by the ED to my petition. Notice is not yet given.
So notice possibly that they will notice.
Which is my submission. What we can do is let them file a short whatever they want to say. Because when I deal with 45, I have to deal with what they are saying. I cannot conjure up an allegation against myself and then deal with it. I must deal with specific issues that they point. I have certain legal I have stands in that, because otherwise we will digress. The Lordships are right, but at times we were on a slightly different. The Lordships today are hearing. I am only taking a submission. Let them put in a short note. Also put in a short note with the relevant topic, so that we are able to crystallize.
Then we'll make it a harding part. Harding part matter. Harding part already is there. Affidavit by 10th.
Very good.
10th November 2023. List on 20th November 2023. Rejoined.
I'm most.
Matter is hard in part.
We'll do that.
We are in 61. File there. Notes. Short written notes.
60.1.
Grateful.
It's a case without seeking anticipating. That's not without a case of me. Because this is also a case of a lady who's 71 years of age. My son. Now, three, four factors. The construction of the provision, my friend has said, and I support that. That in the case of a woman, the rigors of that will not apply, and the court has a discretion to grant or not grant. Nothing automatic. That rigor will not apply. That's on 45. Now, in this case,
so we pass the same order here.
Lord, I am seeking very order. I am 71 years old. My son will not is in custody. I was not there. My son's hotel room was there. I have not been with respect. I am the mother. I have not been arrested in the entire time of investigation. I never the complaint. Then I am entitled to under the judgment of this court in this case. I am not a person.
Let it come on that. We are fixing it on the reopening date itself. Issue notice.
Investigation is
I was not arrested. So Lordship may ask them, I was not arrested. She's like 71 years old.
No, I have no instructions. In the other matter, there was a caveat. In this matter, there's no caveat. I have no instructions to
The Lordship may give me protection.
Not yet.
Give me protection. Then hear it on 20. She's 70. I can.
Then we can let him take instruction. We can post coming week.
So my matter may come on 10th. No problem. My matter may not come on 10th. They can file a reply in 3 days because it's anticipatory. Let it be separated from this. It's a case of custody.
We argue on the
put in a report.
Clear matter. Issue notice. Learned advocate of the court for ED accepts notice. Stop. Let counter affidavit be filed by six.
No problem. Whenever.
7th, my lord, 7th.
November 20, list on 10th November.
But 7th, I'll file the affidavit.
Yes.
One more day, 7th. Grateful.
So Raju, you were.
I was saying instead of 6, 7th, my lord. Affidavit
So
will
they
file
could
by
ask for
7th.
If they file by 7th, I by 7th, I'll by 8th.
Grateful.
Because I'm in a hurry. I'll file rejoinder.
Matter is hard in part.
We heard on 10th.
Whatever you file, rejoinder to be filed in the meantime.
Yes. I'm not in 61. This is a separate case, but nothing to do with this batch. Lord, here my client is in jail for 4 years, below. In a 7-year sentence, there is not a single disease, below, which is not suffering from. He has a heart attack, a pacemaker, diabetes, stents, below, urinary tract infection. He has incontinence. He is 71 years of age. He is currently, below, in a government hospital. Now, I wanted to be treated in my own hospital. The High Court recognizes, below, my bail is pending, below. 4 years he has served already. I wanted it to be treated in a private hospital at my cost.
JJ hospital is.
Sorry, not JJ's government. Now, High Court says that recognizing that I have all this, the High Court says that from JJ you should shift to prison hospital. We will direct the male nurse to go from 10 to 6, stuff like that. When you recognize this is the problem, Milord, should I not be treated, Milord, in my own hospital at my cost?
Which hospital do you want to go to?
Kokilaben, Milord, there is an Ambani Kokilaben hospital. I was treated there earlier. Milord, this is not fair.
He should not.
Milord, till then, Milord, he should not be sent to the prison hospital. He's in government hospital. Let him be there.
There is that direction.
Yeah, Milord, there is a direction. My Lord may be pleased to turn to the last part of the order. Your Lordship will be pleased to find paragraph 11. Let him remain in JJ, Milord. Not shift.
Issue notice.
Grateful.
Service to be effected on
Standing counsel.
standing counsel for the
State of Maharashtra.
For state of Maharashtra. State of Maharashtra, or this is ED?
No, Maharashtra. It is not ED. Okay. After a long time, I have come across a case, Milord, which is now by a state.
But this is part of that DHCL.
No, this is, Milord, another company. The name is similar.
Okay.
Is not that. That is also before your Lordships. But those are different. That is DHFL. This is HDIL.
Okay.
They are different. The surname seems to be same.
Returnable on Tuesday.
Make it Friday, Milord.
Friday, too many matters.
Milord, can I request for Thursday?
Thursday.
I have some difficulty, Milord. That's why
Thursday.
I asked for Thursday in the other case.
Okay, Thursday. Service to be effected on
Standing counsel.
standing.
That's the in addition, Milord.
Until the next date of hearing, let the petitioner remain in
Shall remain in JJ hospital.
JJ hospital, provided hospitalization is
Correct.
necessary.
That's it. Lord, he has a lot of problems. It's completed. It's okay. I'm grateful.
It's urgent.
Oh.